All right, good afternoon, everyone. Welcome to the House Economic Matters Committee. Today is Wednesday, the 28th of February. We have a total of 13 bills and 79 witnesses, so it's going to be a long day. First up, I'd like to welcome back former Majority Leader, now with the Governor's Office, Eric Lukey, and we will start with House Bill 584. You have a panel? Yeah, bring them all up. And then once you're done, you guys can just roll through and keep going.
Thank you very much, Mr. Chairman. Members of the committee, lovely to see you all. We were watching your floor session today with interest. But I'm here on legislation related to workers' compensation and firefighters. And obviously, this is an issue that is not at all new to the committee. I think the committee has taken a very clear stance that workers' compensation presumptions and occupations will be adopted when there's clear science to demonstrate an increased occupational hazard for workers' comp. This bill would expand the presumptions for firefighters related to 3 additional types of cancer, which we believe are now fully supported by a range of scientific evidence. Those are colon cancer, thyroid cancer, and ovarian cancer. And beyond that, before I turn it over to the experts, I want to just say I appreciate this committee's leadership, but really the entire General Assembly's leadership in recognizing the particular needs of first responders and particularly our firefighters. I know that many of you last year voted for legislation that MACO had pushed about workforce shortages in firefighting and EMS jobs. And as you all know, that is an absolutely crucial part of our workforce in the state. And the administration and the governor really see this bill as another aspect of that effort to ensure we are taking care of the people that take care of us. And with that, I'll turn it over to the witnesses.
Afternoon, Mr. Vice Chair. Jeff Puddle on behalf of the Professional Firefighters of Maryland. Just some opening remarks to give some context on cancer and how it's impacting our members that serve the citizens across the state of Maryland. Each September, the International Association of Firefighters honors all of the fallen firefighters from the previous year. And it's actual line of duty deaths, but it's also occupationally related diseases that are recognized by the respective state or local governments. And each year when we have that memorial ceremony out in Colorado Springs, approximately 65 to 75% of the names that we're putting on the memorial wall are of occupational cancers, just to give you some context. And that's hundreds of people that we're putting on a memorial wall each year that have contracted and passed away of cancer that was deemed to be related to their occupation. A couple of things I submitted on my written testimony. We have some scientific data to support these 3 cancers. I also included a chart that demonstrates what other states are doing on these 3 particular cancers. And then finally, for those of you that are really interested, there is the pages at the end of the document with all the studies that provide the medical support for the 3 cancers that we're asking to be added to the statute. So we have our Deputy Director of Health and Medicine here today from the International Association of Firefighters, who's going to go over briefly some of that data that is contained in my written remarks.
Good afternoon. My name is Raquel Cisnales, and I'm the Deputy Director for Occupational Health and Medicine at the International Association of Firefighters, and I'm also a Maryland resident. The IFF is an international union representing 344,000 professional firefighters and EMTs in the United States and Canada. I want to thank the committee for the opportunity to speak in support of House Bill 584, the CAPES Act, to expand firefighter cancer presumption in Maryland to include thyroid, colon, and ovarian cancers. Cancer is the #1 health issue facing firefighters. Firefighters have an increase in cancer incidence and mortality compared to the general population. Due to the overwhelming data from research studies, the International Agency for Research on Cancer reclassified the occupation of firefighting from possibly carcinogenic to a known human carcinogen. In 2019, Maryland passed a law that covered several occupational cancers as presumptive diseases for firefighters. However, presumptive legislation must reflect the latest science. House Bill 584 is important because it helps further protect firefighters by recognizing thyroid, colon, and ovarian cancers as presumptive. There are studies and evidence linking these cancers to known toxic exposures from firefighting. Research indicates a 2-time increased risk for thyroid cancer in firefighters, given their exposure to dioxins, formaldehyde, diesel exhaust, benzene, PFAS, and flame retardants. All of these known carcinogens are found in the fire environment. Multiple studies found elevated colorectal cancer incidence and mortality in firefighters. These increased rates of colon cancer are a result of exposure to arsenic, asbestos, formaldehyde, and other known fireground carcinogens. While there is a smaller sample size for female firefighters, there is sufficient data to support the elevated incidence and mortality of ovarian cancer may be associated with regular exposure to endocrine disrupting chemicals, asbestos, and benzene in the. In conclusion, the IFF supports passage of House Bill 584, and I thank you for the opportunity to speak to you today on this very important issue and welcome any questions you may have.
Good afternoon. My name is John Hall. I'm here just to give a practical standpoint. I'm an attorney. I proudly represent firefighters and police officers in the state of Maryland who are injured in the line of duty. Specifically, I wanted to bring up something that comes up quite often, is that when everyone hears the word presumption, they assume that's an automatic. It is not. If anyone on the other side of the aisle for me states otherwise in the defense side, they fight every one of mine. I don't have any of my cancer cases that don't go to hearings. And I'm telling you, I probably handle more or as many as anyone in the state. So just because it's a presumption doesn't mean it's automatic. They have a doctor say it's not related. We have to go before a commission. The commissioner takes everything into all the facts in place. The medical literature is clear. We rely on that. But as far as the cancers are concerned, this bill really does clear up something that's been coming up a lot. The colon cancer versus rectal cancer. There's some discrepancies, and this will clean that up because one is in and one isn't. If they're both in, it won't be as much of an issue for us. So from a practical standpoint, this bill really helps our firefighters and for the cancers. It's going to help us get these through quicker and help the firefighters who are sick. I can tell you that I personally represented one of the first brain cancer cases in the state of Maryland. My friend Chris Hill, who passed away. I represented one of the first female firefighters with breast cancer. These bills are real. They fight them all, and the presumption is very, very necessary for us to get these through for the firefighters that are sick and have served our community. Thank you very much.
Mr. Chairman, I would be remiss if I didn't point out and thank Delegate Pruski, who carried similar legislation last year, for his efforts and for working with us as we continue to push.
Thank you so much. Just real quick on the ovarian cancer, correct me if I'm wrong, testicular is presumed, correct? And so that would kind of put
That's correct.
both genders in the line. Okay. Seeing no questions, that concludes this panel.
Thank you, Mr. Chairman.
Thank you.
Okay, we have James Lanier, Kenneth Berman, Brianna January, and I apologize, Brianna, hold off. You're favorable with amendments.
Thank you, Mr. Vice Chairman. Mr. Vice Chairman, members of the Economic Matters Committee, my name is Jim Lanier, and I'm here on behalf of the Maryland Association for Justice. The MAJ is a specialty bar association whose members represent and advise injured workers on their workers' compensation claims. We support the bill and ask for a favorable report. Beyond that, we don't really have anything additional beyond what the other panel has already said.
Afternoon, Kenneth Berman. I am also an attorney who represents firefighters, maybe not as many as Mr. Hall, but a bit longer. And I guess my only purpose here is to, because I was here at the creation of the presumption, and maybe to give the committee just a very brief historical background. In 1981, when we first passed the presumption for the 5 cancers, we were in the leading one of the leading states in the country to do so. Over the next 20 years, we became one of the states with the fewest presumptions in the country. We rectified that in 2013. We further rectified it in 2019, bringing us pretty much on par with most of the states and just about all of the provinces in Canada. What this bill would do with both ovarian, actually all three, ovarian, colon, and thyroid cancer, excuse me, would basically put us on par where we should be and where the legislative intent was in 1981 when we decided to basically protect firefighters. Thank you.
Thank you. And I was born in 82, so clearly we need to update.
You're not the first.
Seeing no questions, we'll go to favorable with amendments. Brianna, January.
Thank you, Mr. Chair, esteemed committee. Brianna January with the Maryland Association of Counties in support of HB 584 with an amendment. Counties appreciate the intent of the bill, and as Delegate Lukey mentioned, we are working very strongly with our partners on a commission and recommendations to support hiring and retention of our firefighters. That said, we do have some concerns around the fiscal note with the bill. For context, I just heard from Baltimore City and they're expecting this to be in the millions for them. We understand that this is a priority bill for the administration and this committee. As such, we're just seeking an amendment to provide some state aid to help support those claims. With that, we appreciate your consideration of that amendment. Thank you.
Thank you. And we know Eric still wishes he was here. All right. Seeing no questions. Oh, apologies. Delegate Turner.
The physical note was high. Did you, I'm looking through my papers. What was it?
For Baltimore City in particular, they are expecting, I believe they stated around 12 million annually. I've heard some similar expectations from other counties. I'd be happy to get you yours in particular if that's helpful.
Prince George's.
Yes, I know.
Yes.
Me
Okay.
too.
You too. Okay. Wow. Okay. Good. Thank you, sweet.
Thank you,
All right.
Delegate.
That concludes this hearing. So next we will go to House Bill 190, Delegate Hill.
Good afternoon. I don't think there is a panel. I'm making this easy. Or if you have other witnesses there who are here that are favorable, by all means, ask them to come up, but I don't have a list. Okay. So I'm Delegate Terry Hill, and I'm here to present House Bill 190, which those of you who have been on the committee for the past couple of years may be familiar with. This is, there is the bill as presented to you, but there is also an amendment, which I would be presenting, as I believe the amendment bill is more consistent with the feedback that I received from the chairman of the committee. Basically, House Bill 190 as written would have asked that all first responders be given presumption for PTSD in workers' compensation claims. We had a good discussion about this in this committee last year, and in discussion with the stakeholders and with the chair, I was asked, what is it that you really think is most important? 2 years ago, I presented the initial bill, which was let's give presumption for the 911 specialists, because the 911 specialists are the people whose cumulative trauma is not as easily recognized. If you're a police officer or a fireman, firefighter, you can usually or often talk about a specific incident that may have triggered PTSD, something you saw, something you were part of. 911 responders, 911 specialists generally are not going to be at the scene. Their experience, the trauma they experience is oral. They tend not to get closure from what they're going through. And so it becomes a lot more difficult to be able to state that there was a particular incident that caused the emotional, psychological illness that they're experiencing. That makes it particularly hard for them to defend a claim of PTSD. What this bill with the amendment would do is go back to that original bill and say, for those specialists, when we recognize that all first responders have an increased rate of 1 in 3 for PTSD versus the general population of about 1 in 5 or less, that this particular group should be given presumption. And by giving them presumption, that should lead to earlier treatment and a shorter time of disability. And that should decrease the turnover rate and increase retention and be good overall. These are highly trained, highly skilled people. And it is important that we not only treat them because they deserve that, but also because it serves our interest to make sure that we can help keep them on the job. So with that, I'd ask you to consider with the amendment, House Bill 190. And you'll note that we have support from many people in the first responder community with the bill as introduced that would have given all the presumption. There's another change to the bill from versus last year in that we're asking for a look back study to be done to look at 3 periods of time, the 4 years before COVID, the 4 years of and immediately following COVID, and the 4 years after this bill would go into effect. And we would look at retention rates of 911 specialists and see if indeed what I expect to see actually shows that we're going to find improved retention when people are able to be treated earlier.
Thank you, Delegate. Seeing no questions, we will go on to the next witnesses. I got James Lanier, James McAllister, Matt Pavola, and Rebecca Smith. You can start when ready, sir.
Thank you, Mr. Vice Chair. So again, ladies and gentlemen of the committee, my name is Jim Lanier on behalf of the Maryland Association for Justice. The MAJ does believe that it's pretty well accepted that 911 specialists do have stressful jobs. And the General Assembly has obviously acknowledged, in regards to the prior bills, the fact that there is work-based stress injuries that should be presumptively caused by the job requirements. With this bill, it would be the first presumption. Right now, all of the current presumptions are physical manifestations of stress or other reasons of which someone develops a disease, hypertension being obviously the easiest one to look at. This bill would be the first presumptive disease for mental illnesses or injuries that were caused by the job requirements specifically for 911 specialists. The other reason why the MAJ is supporting this bill is it would encourage all 911 specialists to seek medical care when they do have mental health struggles as a result of the specific type of work and job requirements that they have. Therefore, on behalf of the MAJ, we request a favorable report.
Matt Pavola, also with MAJ, of course, in support of this bill. Particularly, we draw attention to the fact that this is a compassionate bill with this kind of issue. These are tough folks exposed to these daily trauma, and sometimes it can lead to PTSD. But because of the nature of what they do and every day, day in and day out, they try to disregard it and get over it. But eventually they need treatment. And this bill will make it easier for them to access that treatment. They'll be able to overcome that reluctance, that reticence to come forward and say, hey, I'm really hurting from this. And it'll facilitate this presumption that they don't have to prove their case immediately. They might have to prove their case, but it'll make it a little bit easier to present it for them because they won't face a wall right from the outset. Thank you for this opportunity to testify in favor of this bill.
Good afternoon. Thank you for your time today. My name's Rebecca Smith. I'm actually here for the Maryland Troopers Association. We supported this bill as it included law enforcement officers with this presumption. But also the Maryland Troopers Association also has civilian members, which include PCOs, police communication officers. So we would be supportive of this bill for 911 responders in that regard. And we would join Mr. Lanier and Mr. Pavla, what they've already stated. Thank you.
Good afternoon, committee members. My name is Jim McAllister. I'm a trial lawyer, member of the Maryland Association for Justice. What I want to do is explain what a presumption is, because there's been some misunderstandings over the last couple of years. A presumption is basically allows you to prove something and it shifts the burden of disproving it to somebody else. Under the current system, anybody other than public safety covered by presumptions, it's presumed that your injuries did not happen at work. It's presumed that your occupational disease is not work-related. And you, as the injured worker or the diseased worker, have an obligation to go out and hire experts and find proof that says it is. So right now, it's presumed it's not. Why do we treat these public servants differently? Because they're exposed to things that they can't unbreathe. They're exposed to sounds that they can't unhear. They're exposed to traumatic, graphic, gruesome things that they cannot unsee and unremember. So we treat them differently when it comes to cancer. We treat them differently when it comes to other health conditions like hypertension. Why don't we recognize that what they see, they can't unsee? What they hear, they can't unhear? And when I say a presumption, all that does is say to the employer, look, if you don't think this is work-related, or you think it's a bogus claim because they saw something that shouldn't be traumatizing, then do exactly what the claimant is required to do in every other case. Go hire an expert and go to the commission and prove it's not work-related. That's what overcoming a presumption is. It's not, oh, you're stuck automatically with the presumption. Prove your case. For these people that run towards and do things that the rest of us, thank God they do, let's protect them and shift the burden of proof to the people denying it, their employers who have all the resources, because
come on, here we go. Thank you, Mr. Chairman. I just have a question. It says here to qualify for presumption in the fiscal note. A first responder must be diagnosed with PTSD by a licensed psychologist or psychiatrist. I presume that's post-trauma. Are they required to be looked at, these employees, by a psychologist or a psychiatrist prior to being hired?
Yes, I can tell you that my son is currently training to be a 911 specialist. He had to go through a mental health evaluation before he could begin training.
With a psychologist or a psychiatrist?
I cannot tell you.
Those are actual doctors.
I can't tell you who did his evaluation, but I know that he had to have a mental health evaluation.
Would you support that?
Do I support him having a mental health evaluation? I'm sorry, I didn't hear you.
Would you support having a psychologist or psychiatrist evaluating people prior to being hired to make sure that they are of sound mind to do the job?
Yes, but we would also defer to the counties or the municipalities for what they believe is proper for them.
This bill doesn't defer to the counties. This bill is a statewide bill. I'm asking you
Very
for
true.
a statewide bill.
Yes, we would support.
Okay. How about it says completed at least 2 years of cumulative service within the state as a first responder? So it's just 2 years, and then is there a reason for that?
So because the whole idea behind an occupational disease is it's a cumulative trauma that happens over a period of time. Carpal tunnel is another perfect example. So 2 years minimum is a requirement because anyone who has it before then probably doesn't have the requisite amount of time on the job.
Is there a psychologist or psychiatrist that's on this panel or that you're aware of that's going to testify to validate what you just said?
I don't believe there's a medical doctor who's going to be here today.
Thanks.
Seeing no further questions, that concludes this panel. We'll now go to the unfavorable. Lindsay Menninger, Julie Murray, Brianna January. Start when ready. Oh, I apologize. Michael Daly as well.
Good afternoon. My name is Lindsay Beidel Menninger. I'm the Vice President of Legal Services at Chesapeake Employers Insurance and the President of the Injured Workers Insurance Fund, which is the state's third-party administrator for workers' compensation. We have to respectfully oppose this amendment and House Bill 190. PTSD is already compensable under our case law. It has been since the 1990s. We have two specific cases we point to. It's Means versus Baltimore County. It's a paramedic case. She saw several accidents over her time. The court held that PTSD is compensable as an occupational disease. That's the presumption we're talking about today. We also have Belcher. A big beam came into an office building. The injured worker was not injured physically. The beam came in, the lights went out. It was insane for her. She was stuck at her desk. An accidental injury, PTSD, arose from that. Court found it to be compensable. So both of these matters, AIs, ODs, in workers' compensation, PTSD is compensable. It has been since 1997 with the Means case and 1992 with the Belcher beam case. So that is why we have to oppose it. IWIF, Chesapeake, we already have compensable claims. Your sister jurisdictions with statutes related to PTSD, it's because they do not have the case law that we have today. Thank you.
Good afternoon. Julie Murray on behalf of the Maryland Defense Council here. I am the co-chair of our Workers' Compensation Subcommittee. The Maryland Defense Council is a civil defense organization made up of attorneys and other lawyers from municipalities representing the defense interests in the state. We also respectfully have to oppose House Bill 190. The first big issue that we have with this bill is that the presumption in this case is actually making a claim more restrictive than it is normally under the well-established case law that my colleague mentioned. The bill as drafted indicates that a person has to be employed for 2 years. That's not a requirement for any other occupational disease anywhere else in our statute. Second, the requirement of a person to file a claim while employed or within 18 months immediately after is also not a requirement that we see anywhere else and has removed what is the well-established case law on the compensability of occupational diseases and brought this particular subset of employees and this particular diagnosis of PTSD into a different category. The other thing we would just point out is that the presumption that is being proposed here today does not guarantee either that a person will receive treatment earlier or that they will have a shorter time of disability. All the presumption does is creates a rebuttable presumption where the employer and insurer can then rebut that in court before the commission. All parties still need to appear before the Workers' Compensation Commission for a full evidentiary hearing if the claim is contested. And on that basis, we would ask you to, or we respectfully oppose House Bill 190 with amendments.
Good afternoon, Mr. Chair, members of the committee. Michael Daly on behalf of the Maryland Defense Council. As my colleagues indicated, we oppose this bill. One thing I wanted to address is the fact that these types of claims are regularly filed already before our commission. Our commission hears the evidence that is brought before them, both by medical testimony, typically by reports of an expert witness on both sides, as well as the testimony of the injured worker claiming post-traumatic stress disorder related to their occupation. So the commission does a very good job of applying the law, as Ms. Menninger indicated, is already in existence and has been in existence for many, many years. This bill does not change anything in that regard. And as Ms. Murray indicated, some aspects of this bill actually restrict the way the commission would apply the law as it is otherwise and as it exists today. For those reasons, we respectfully request an unfavorable report. Thank you.
Madam Chair, Brianna January with the Maryland Association of Counties in respectful opposition to HB 190. Committee, you've heard about the technical concerns around the bill, so I won't repeat them. I do want to add some additional perspective as the major employer impacted by the bill, and that is around our concerns with personnel impacts. It is reasonable to believe that under the bill, more folks would be seeking extended leave. And committee, I don't say this lightly, our public sector employment is at a crisis point right now. We're having a lot of trouble to hire and retain at all levels, especially for our first responders, whether they be our public safety officers, our 911 call takers, or our detention center folks. So we're concerned that under the bill with folks seeking more leave, that'll mean fewer seats filled at our 911 call centers. We cannot hire and backfill those seats currently. That means a direct impact, unfortunately, for our mutual constituents. When they call into 911, they might have longer wait times. They might have not as adequate responses to their emergency situations. That is something that counties do not want. It's something that you do not want. With that, we urge an unfavorable report. Thank you.
Thank you very much. Are there any questions for these panelists? Seeing none. Oh, Delegate Harrison.
Thank you. I'm sorry, I forgot your name from IWIP. Because I wrote down IWIP. So my question is, how many, you said that this is, it's already doable. My question is, how many times have individuals in this capacity come to you seeking assistance and have been denied? How often does that occur?
Denied initially or denied forever?
Doesn't matter.
Oh, okay. So in the last 5 years, we've had 328 claims where PTSD is within the claim form. Some of them are denied initially because we have to have a hearing to see who the last injurious exposure is. If it's related to their employment, PTSD presumption wouldn't change that. I don't have the specific numbers of how many is denied at the end of the day. That is something that the Workers' Compensation Commission might have, but it's very few and usually on a technicality and not because of the actual issue of PTSD is related to employment.
Okay. And then Ms. January. I understand what you were saying about personnel and not having them, but if an individual is in a mental health crisis and they maybe unknowingly and they continue to take these calls, they're hearing babies crying and gunshots in the background and other torturous matters. So then they then may become a victim of one of these 911 calls, because the problem I think that we're seeing or we're concerned with is what may happen to those individuals who are constantly exposed to this trauma. And so I guess I'm a little concerned maybe that we are saying it's more important for you to stay on the job and deal with this than take some time. And so how do you respond to that? Because this is mental health, we know, is very real, and everyone now is at a stage where they're accepting that mental health challenges are real. And so I think that that's what we're talking about right here.
Absolutely. Thank you for that question, Delegate. That is in no way, shape, or form our position. So to be clear, what we're concerned about is, again, as my colleagues noted, folks can already take the leave for PTSD and have it be compensated through workers' comp claims. We're concerned that the legality of making it a presumption might have an influx of claims kind of out of nowhere, like we've seen with other benefits where folks are now thinking that because there's a presumption, everyone's automatically going to be checked off and can take leave. That's what we're concerned about, is having an influx where we're seeing a real impact to the 24-hour seats that we need at 911 call centers. That said, we share those concerns greatly with you, and our folks at our 911 call centers are the very first point of contact for our mutual constituents, for God forbid one day you or me. And we take their health and their mental health very, very seriously. And we'd love to chat if you have any ideas about furthering support for benefits around mental health. In the meantime, the bill is drafted. We're worried about that influx and what that would mean for services.
We heard testimony earlier that presumption is not automatic. They still have to go to the hearing. So I guess I'm not understanding, I'm maybe misunderstanding what it is that you are saying, that even though there may be perhaps additional claims, they still have to go through a hearing. So they don't automatically
Absolutely. A lot of people don't know that though, when they go and they submit claims, they don't understand the full process. So we're kind of worried about the mentality of this is a new, people thinking that this is a new benefit. It's really not. It's already available and compensable, and what that would mean for folks thinking that tomorrow they can sign up and start taking leave. They would have to go through the full administrative process, but that kind of education piece, I think, is still a little bit lacking on the employee side sometimes.
So sorry, Madam Chair, one more, or just for my education.
Yes.
So then I'm a 911 specialist, and I come to you, my employer, and say, you know, I can't do this. You know, I need some help. I need to step back. What then is the process? Do I automatically go home and I stay home until the hearing, or how does that work? And then someone should explain that to me and the general public.
I think it depends on who your employer is. So some employers like the state have an EAP program. So they're going to send their employee to an EAP program outside of workers' compensation to ensure that they have, the help they need immediately. Filing a claim might be something that happens down the road because you have a certain length of time to file that claim and recognize that what you're going through is something that you need additional help for. So I think most of our counties, our insured counties for Chesapeake and then the state of Maryland, both would send as the employer immediate help, whereas we're still on the workers' compensation side here. There is immediate help that's there provided by the employer in that situation that you're giving.
So I guess that goes back to why I don't understand your claim about the possibility of more people trying to file a claim and then seeking this time off, because there's a process in place. They don't automatically go home. They won't automatically be gone from their seats, is the way that I'm understanding what I just heard.
There are procedures in place both for the immediate, if someone, just like in any other capacity, has some sort of crisis, if you will, and in the long term when it comes to things like the workers' comp benefits. What we're hearing just time and time again from all of our members, whether it's Western Maryland to Prince George's County and the metro region to the Eastern Shore, is that we can't fill these seats as it is. So there is just a very big fear in general of any sort of policy that might kind of exacerbate that and might put even more strain on the very delicate systems that we have now. It's up and down the board. It's just a complete concern for everyone.
Okay. Thank you. And just for the panelists' information, she's our new currently subcommittee chair on workers' compensation. So thank you for your inquiries, Delegate Harrison. Any other questions from the members for this panel? Seeing none, thank you very much. As far as I see, this concludes the hearings on House Bill 190. We now move on to Delegate Pruski, House Bill 915.
Good afternoon. While the folks are sitting down, I'm just going to get started. Madam Chairwoman, thank you. This is HB 915, Workers' Compensation, Uninsured Employers Fund Timely Payment of Awards. In brief summary, this legislation will amend statute to require the Uninsured Employers Fund to begin paying compensation for workers for a certain time period and apply certain provisions of law regarding the failure to make those that payment. The bill is designed to close a loophole, and that the Unemployed Insurance Fund, or UEF, used to avoid making payments on workers' comp claims and applies a certain provision under the law. If you look at the Maryland Workers' Compensation Act, the goal is to assist injured workers to recover from injury and return to the workforce. I want to provide a little background to the committee members so you understand the purpose and intent of the UEF. So the Uninsured Employers Fund is a self-funded agency that protects workers who don't possess workers' comp insurance. It ensures those awards are paid to those injured workers, and those without insurance are liable through sanctions. The bill requires the UEF to make those payments in the same manner as insurers and employers. When the Workers' Comp Commission has determined that the UEF has paid a benefit to injured workers, it compels the UEF to provide that compensation 15 days after an award is made or 15 days after payment is due. The regulation is supported by fines, then awarded by the commission and then paid to the covered employee. If compensation is not provided after 30 days, then the UEF could be fined an increased amount. The restriction will ensure that the injured workers get compensation in a timely manner and holds UEF to the same standards and rules as other stakeholders. This bill aims to protect injured workers who've already been victimized due to an employer breaking law for failing to have workers' compensation insurance. One of the first questions when I review is not only the fiscal note, but I did a little homework. If you look at my testimony, which is in your system, you will find that I pulled the Maryland Insurance Employers Annual Report dated September 26, 2023. For the sake of time, I won't read the report, but I'm going to highlight a few things that the committee should really read at. First, number one, the mission statement on the first substantial page of the report states, and I paraphrase, the Maryland Unemployment Insurance Fund exists to protect workers who employers fail to obtain workers' compensation insurance and pay claims. I also want to reference, you look at the bottom of page 8. The Maryland Uninsured Employers Fund has been and remains solvent. Why is that a big deal with this bill? Because we always ask where money's coming from and what's there. And I will highlight again, the September report said that this is solvent. In simple terms, I want to clarify that the UEF fund should be paying claims in a timely manner. What's at stake is the remedy. This bill simply adds the Uninsured Employers Fund as a party to pay awards in a timely manner. There are no changes to fines, dates, or presumptions. Currently, we have employees who have been adjudicated, then appealed. The Maryland Workers' Compensation Act requires that awards and benefits to an injured worker are even provided on appeal. The anti-state provision in the Maryland Workers' Compensation Act is followed by the employer and the insurer. In conclusion, UEF should be a party for paying timely claims and more reasonable and timely payments for that claim. And we should honor that benevolent purpose and intent in their own mission statement. There are several witnesses here today that can provide legal, substantive, technical, and background information on why you should support this bill. I respectfully ask the committee for a favorable report. Thank you.
Again, James Lanier on behalf of the Maryland Association for Justice.
James, if you could speak into the
I'm
microphone.
sorry, Madam.
Thank you.
Again, my name is James Lanier on behalf of the Maryland Association for Justice. So when the commission makes a decision, an award or an order, and it's appealed by a party, there's an anti-state provision. So if the employer insurer required to pay benefits, they still have to pay even though they file an appeal. And the provision as stands for penalties is if they don't timely make those payments, whether there's appeal or not, they could be subject to penalties. And generally speaking, there's not a problem. Employers and insurers do pay timely. The UEF, however, takes a different position. If any appeal is filed, then they take a position that we are not required to pay while an appeal is pending. Getting ready for today, I was able to review the written testimony provided by the Uninsured Employers Fund in opposition to the bill. Point one was that there's no current problem of untimely payments from the UEF. This is just inaccurate. It's just wrong. I have an affidavit in one of my cases from a medical provider that I provided. The UEF representative informed me that even though there was an order from the commission authorizing medical care, that the UEF would continue to refuse the authorization for the medical care, even though the medical care has been ordered by the commission, and will not honor the order of the commission until the appeal is concluded. An email from a UEF representative. The UEF will not be able to make payments under a final order is entered until the conclusion of the appeal. 2 orders from the commission. Commission notes that the UEF filed an appeal of the prior order. Nonetheless, the commission finds that the pursuant to 9741, the appeal is not a stay of the requirement to pay benefits under the award. And the second order in the same case says the same thing. So in the same case, the UEF was ordered to pay, refused. Commission said, pay, they still refused. Commission said, so in that regard, the idea that there's not a problem, and this is still going on today. There are MAJ members who are indicating that the UEF is still taking the position that if it's on appeal, they don't have to pay any medical or indemnity benefits to the injured worker.
Matt Pavola, also with the Maryland Association of Justice. I would just want to say, echo what Jim Lanier, my good friend, just shared. Anecdotally, it's not as the written testimony of the UEF has stated. It just isn't. The reality in the streets, in the trenches, at the commission, is that the UEF stands above the law that way, and they will not, during an appeal, willingly make payments. And this, as the delegate Bruschi just so eloquently pointed out, this is a really minor change. We're simply adding UEF to already the muscle that the commission has to make their orders have muster behind them, make their orders have enforceability. UEF now is specifically listed along with employers and insurers. As Mr. Lanier mentioned, we don't find this problem typically with employers and insurers. This is a UEF unique issue, and we would ask you to consider and pass out of this committee this very innocuous change of adding UEF to this particular muscle that the commission has existing now in 9727 and 9728 and 9741 of the existing law by adding UEF. Thank you. Thanks so much.
Good afternoon, members of the committee. My name is Jim McAllister. I'm a trial lawyer doing workers' compensation cases for over 30 years. So let's look at what the UEF is. When you're injured on the job, the reason we call it workers' compensation isn't just the name on the building. That's actually a mission statement to make sure that damaged, injured workers get health care, get compensated so that they can pay their mortgage, they can get back to work. These are benefits that are designed to help injured workers and their families. And when those benefits are not paid, the system breaks down. Well, the person that gets screwed the most is the claimant in a UEF case, because the problem is their employer broke the law and didn't buy workers' comp insurance. And now they've got to fight with the UEF to get paid. Now, if the UEF says, we always pay these penalties are not necessary, pass this bill. Because when you pass this bill, you know what the fiscal note will be if they come through with what they're saying? Zero. Because they will pay every claim on time and they will never get hit with fees and penalties. So the fiscal note will be zero, and the big winners will be injured workers, because waiting is not an option when the mortgage is due. Waiting is not an option when your medical bills need to get paid. Waiting is not an option when you need surgery. It's not an option when you need vocational rehabilitation because you're damaged so badly you can't go back to doing the job you had. Workers' compensation is not just the name on the building. It's a mission statement. Pass this law, and if the UEF isn't doing anything wrong, let them continue to do nothing wrong in perpetuity, and they will never regret the passage of this bill. Thank you.
Thank you. Are there any questions for this panel? Seeing none, thank you very much. We'll now move on to the unfavorable. We have Mr. Michael Burns.
Madam Chair, members of the committee, I want to thank the proponents of this legislation for bringing it, because it has been many years since I served in the General Assembly, and I've not had the benefit of hearing testimony that is so wildly inaccurate in quite some time. And it was certainly a revelation to me to know that the Uninsured Employers Fund could not apparently care less about our injured workers. However, the reality of the situation is somewhat different. First, I would strongly urge you to please look at our testimony, please, about this. You know, I also used to be a judge, and when I was a judge, I used to have cases where a party would not mention a very important fact. And I at first was like, well, why won't they mention that fact? But when you research the file and see the case, you will find out often why that is, because the party doesn't want you to see that fact. That is the case today. The Uninsured Employers Fund is not an insurance company. It is not an employer. It is a state of Maryland statutorily established fund which pays based on the requirements of a statute. And that statute, to be blunt, ain't 9208-2728. There is a different statute that sets out an entirely different process, which we follow. They've also failed to mention a case called Danner to you. Danner, UEF versus Danner. I know I'm repeating it, but that's because the proponents didn't seem to find the time to say anything about it. This is a 20-year-old case, ladies and gentlemen, 20 years old. And today you hear that it is a crisis in the workers' comp industry that we don't pay on time. Nothing could be further from the truth. In a nutshell, in Danner, the Court of Appeals of Maryland stated that if a matter, and I've got with me Dave Stash. Chair, may I continue? Okay, who is here as our principal counsel who can explain this further. But in a nutshell, if an issue when we take an appeal is absolutely essential to the appeal, we don't pay. If the issue is not absolutely essential, we do have to pay. And that comes from the Court of Appeals. It's not me making it up. It's not the agency making it up. It's from the Court of Appeals. All right. In conclusion, I would simply like to read you a quote from the Danner case. The fund could not, at the risk of a punishable failure, be subject to the same time restraints that apply to an employer or an insurer. And you know why? Because we're a state agency, we're not a private entity. It's impossible for us to implement this under the other statutes. That's simple. Mr. Stesh, I think, can explain it more articulately for you all.
I actually don't have you signed up. Do you have them?
Well, he tried to sign up. He's just here for information purposes. I'd really appreciate it if he could, as an Office of Attorney General, to explain the issue.
Sure.
Thank you. I really appreciate that. Thank you, Madam Chair.
Thank you, Madam Chair. Just briefly, I'm here solely representing the Uninsured Employers Fund. The Office of the Attorney General has not taken a position on this bill, so I'm here for informational purposes only. What was clearly misstated by the proponents of this bill is the blanket statement that the UEF does not pay benefits if an appeal is filed. That is simply not true. Pursuant to the Danner case, which is 20 years old, we only do not pay benefits if all the statutory provisions of our triggering statute, which is not addressed in this bill, are not met. The triggering statute is not met and an employer is not in default if an appeal is filed that goes to the validity of an award. If a timely appeal is filed and it goes to validity award, the employer is not in default. An appeal on a collateral issue, which was actually involved in Danner, was a collateral issue of statutory employer. If any collateral issue is on appeal, if all the statutory requirements are met, the UEF will pay benefits. Those statutory triggers actually requires claimant and claimant's counsel to take certain steps to get paid pursuant to the statute. And also just like to point out, as case law has made clear, unlike an employer and insurer, the UEF does not pay based on orders issued by the Workers' Comp Commission. We pay pursuant to our triggering statute. And when all those conditions are met, even if an appeal is filed, we will pay benefits. Thank you.
Thank you. Are there any questions for this panel? Seeing none, thank you very much.
Thank you again for your courtesy today, Madam Chair.
Sure.
Oh, I'm sorry.
Delegate Turner.
Okay, thank you. Okay, this bill is, I'm looking at the last little statement here, timely payment award. So do y'all pay your awards on time? Because this is what this bill is stating. This is what this bill is for. So y'all two are against this bill, correct?
Yes, ma'am.
Okay, for y'all awards, do y'all pay and a timely awards here?
You raise an excellent point, Delegate. Again,
Yeah. I'm listening.
the commission issues an award. It's an order directed to employers and it's directed to insurance companies. It is not involving the uninsured employers fund. We pay pursuant to a different statute in the code, which has a fairly lengthy process that has to be gone through. Basically, when the employer is legally found not to be paying, we are triggered. it is not within 15 days of an order, we never are going to be subject to an order. We can't be subject to an order because we are covered under a different section. So that part of the statute makes no sense. I don't know how, if there was an award from the commission and they named us, we'd have to litigate it. It makes no sense at all. We pay when an award is due and owing, but that is different than this statute, as the Court of Appeals in the Court of Special Appeals in the first Tanner case and the Court of Appeals in the second Tanner case that reviewed the first Tanner case said. So we do. Sure, we do. That's why we're there. We're there to help injured workers.
Thank you very much.
Sure.
That concludes the testimony and hearings on House Bill 915. We'll now move on to Delegate Pruski again with House Bill 1050.
Thanks again.
Thank you, Madam Chair. I promise this is the last one for today. HB 1050, Workers' Compensation Modification of Award Extension. So good afternoon, Madam Chairman, members of the committee. I'm here to testify on 1050, Workers' Compensation Modification Award Extension. This bill is designed to briefly extend the period in which the Maryland Workers' Compensation Commission maintains jurisdiction over modifying certain awards if the original time period for requesting a modification lapsed while a claim is on appeal. A worker may request a modification to a prior commission award as long as the request is made within 5 years after the date of the accident, disablement, or the last compensation payment. This bill would extend that amount of time for an injured worker to request the modification with the commission by 60 days. The commission doesn't have jurisdiction to decide modification of prior awards while a claim is on appeal. The 60-day extension would allow the claimant a short additional time to request that modification when the 5-year runs out while the appeal was pending on the commission, which lacked the jurisdiction to decide if the modification should be granted. The extension of the authority of the commission would contribute to decisions to ensure that workers receive the proper consideration by the commission that is correct for those circumstances. This bill will also clear some of the commission's pending hearing docket, since injured workers no longer will have to request hearings when the commission lacks jurisdictions to resolve the dispute. So let me state this clearly for the committee members. This bill would simply allow for modifying workers' compensation to be more effective, efficient, and a process due to the extension of time that the commission has jurisdiction to decide if that modification should be granted. Consequently, workers will also receive the award that is appropriate for them and their particular situation. You will hear testimony today from some of the advocates on why this is needed. This is a policy decision. Let me repeat that again. This is a policy decision of the legislature, and I ask for a favorable report. Thank you.
Ladies and gentlemen, James Lanier on behalf of the Maryland Association for Justice. So this is a very small change, and admittedly, this does not happen very often with regard to workers' compensation claims. But when it does, when the perfect storm occurs, it could be detrimental, fatally detrimental to the additional indemnity benefits for the injured worker. The best way I can explain this bill is how it affected one of my clients. My client, 4 years after the last payment, needed a revision neck surgery. And we went to the hearing, and the commission, for their reasons, denied the surgery to the client. I file an appeal. The 5-year clock for that client is still going. So what happened? So that appeal is going to take longer than the rest of the time he had. So what ultimately I have to do, and this is mentioned in some of the written testimony from the opponents, is I have to file issues, in other words, request a hearing, when the commission doesn't have jurisdiction to decide a modification. So ultimately, we have to keep continuing, and hoping and praying that the commission doesn't just withdraw the issues, because if those issues are withdrawn and the 5 years is up, the client can never come back. So how this affected my client was eventually the insurance company agreed that the guy needed the surgery, and he's still getting out of work benefits right now, post-surgical intervention. But had I not filed those issues that the commission didn't even have jurisdiction to hear, his 5 years would have been up. He still would have gotten his surgery. They agreed on that, but he wouldn't have been able to get out of work benefits up and until right now. So it's basically when you have a situation on appeal, the clock doesn't stop, but the commission lacks jurisdiction. They cannot decide the modification. So the 60 days is just when the appeal is over. If there had been the 5-year lapse during that time, you have the 60 days to file the modification request and make the decision whether a modification should be granted or not. We ask for a favorable finding.
Committee members, good afternoon. My name is Jim McAllister. I've been a workers' compensation practitioner for a long time. So let me explain how this comes up. When you get injured on the job, you have the right to lifetime benefits. So between now and eternity, you have the right to medical treatment as long as it's causally related and reasonably necessary. With regard to compensation, which is money paid to injured workers if they're off getting a surgery or injured or in a voc rehab program, those are treated differently. There is no right to lifetime benefits. You have to request those benefits within 5 years of the last payment of compensation. So if I have a workers' compensation award in 2019, and it's now 5 years later, and the client doesn't reopen for worsening of condition, and then now they want a surgery, they can get the surgery, they can't get paid for the time off recovering from the surgery. It's the right to get all the medical care you can't afford to take time off to get. That's why reopening benefits are important. The purpose of statutes of limitations is to say, look, if enough time has passed, let the insurance company close their checkbook because nothing's going on. But it's completely different when there's an appeal pending. And that brings up something about workers' comp that's different than any other litigation. When you go to court in a car accident case and you lose and you take an appeal, your case goes up to the appellate court. But because we want injured workers to be able to get benefits, if I lose an issue at the commission and I take an appeal, I can still go into the commission and request certain benefits as long as they're not addressed by whatever's pending on appeal. So the commission loses jurisdiction to handle things that are pending on appeal. That's what this bill does. It says if the 5-year clock runs out while the appeal is running, then let's hold it until the appeal is over because we don't want people's rights to die.
Thank you. Any questions from members? All right, thank you very much, panel. We have an unfavorable panel, starting with Lindsay Manager, Julie Murray, Andrew Griffin, Nancy Corson, and Michael Daly. Please come up if you are here.
Good afternoon, Madam Chair, the person in the seat, and members of the committee. Andrew Griffin, for the record, here on behalf of the Maryland Chamber of Commerce. I've asked Nancy Corson here, who's the chair of our Workers' Compensation Policy Committee, to answer any questions you may all have. The Chamber's position on this bill, I want to just offer kind of a different view from the employer side. By extending these timelines out, we're exposing employers to additional cost burdens, to additional claims. And I don't think it's said often enough on, in workers' comp and on the issue, the employer side. And so I just want to hit on that. It's very straightforward for you all to consider. We heard earlier in the panel that it's these are rare circumstances. So we would just urge an unfavorable report on the bill. I'm happy to take any questions. Thank you.
Good afternoon, Madam Chair, members of the committee. Michael Daly from the Maryland Defense Council. We respectfully request an unfavorable on this bill, and our opposition is based on many different fronts. I won't promise I won't touch on all of them. Some of them I would like to touch on immediately, however, is the fact that Maryland already provides a very generous, what we call reopening provisions under the law. 5 years from the date a last payment of any kind, we call them indemnity benefits, lost time, permanency. An injured worker has the right to file with the commission and come back and say, my condition's gotten worse. I can't work now again because of my work injury. Contrast that with Virginia and DC. They don't have those reopenings. There is no such thing. Essentially, it's a year. And if you can't come back and ask for more benefits. So I think the state already does a really good job of treating the workers really fair and favorably in terms of if their conditions truly require additional lost time, additional permanency because things have gotten worse, it's already off. In addition to that, procedurally, under the law, there is a fix to it. The injured worker can file issues with the commission. That was mentioned, I believe, by those in favor of the bill. They can already do that. There's nothing under the law preventing them from doing that now. And because of the small numbers, and I think others may touch on that, it simply is a bill that's not necessary to fix a problem that exists. Thank you.
Good afternoon, Madam Chair, members of the committee. Julie Murray, again, on behalf of the Maryland Defense Council. Again, we are urging an unfavorable report on this bill. I will just touch a little bit on some of the numbers that Mr. Daly alluded to. This is not a large problem in our workers' compensation system. A poll on behalf of the Maryland Defense Council members showed that not one of our members could recall a particular instance where this had come up in the last year in a case. It is simply not something that is prevalent in our practice. And as Mr. Daly mentioned, if it does come up, if a person appeals an award and runs up against that 5-year statute of limitations, which is quite generous, they currently have a remedy. The commission does an excellent job of permitting them to file issues and postpone those issues until the appeal is resolved. We think this is looking to fix something that is simply not a problem, and as such, we would ask for an unfavorable report. Thank you.
Lindsay Vital Menninger again, Chesapeake Employers Insurance and IWIF, the Injured Workers Insurance Fund. We just wanted to point out that the bill as written doesn't probably solve the problem that we're seeking to resolve. So the idea would be that you would have another 60 days after the 5 years ran because it was on appeal. So the remand happens, the appeal is resolved, and then you would have 60 days. The bill as it reads currently gives you an extra 60 days if you happen to file an appeal, but it's not an additional 60 days after the appeal is closed. So it's essentially just 5 years and 60 days. So it doesn't actually resolve the remand issue that is being spoken of today. So it would need amendments to resolve the issue it's trying to resolve, which again, not to reiterate, is a very limited concern. Thank you.
She's just here for questions, Madam Chair.
Thank you. Any questions from our members for this panel? Okay. Thank you. All right, next, we're going to switch order a little bit. We're going to jump to Bill HB 702, which is the chair's bill. Since he's not here, we're going to just call upon the two witnesses that are here. Okay. 702. Okay. Is Keith Wamsley, okay, and Stephen Gonzalez? Okay, great, thank you very much. Please go ahead.
Madam Chair and distinguished members of the committee, it's nice to be here again. For the record, my name is Keith Wamsley, here in strong support of this bill. I would like to refresh all of your memories that this bill's cross-file has already passed the Senate unanimous. It's my pleasure to introduce you all to my friend Steve Gonzalez here today. On behalf of Major League Baseball, he is the expert, so if you have any questions, he'll be the one to answer them. So with that, I urge a favorable report. Thank you.
Vice Chair Crosby and distinguished members of the Economic Matters Committee, it is my pleasure to come before you and offer testimony in favor of House Bill 702, Wage and Hour Law, Minor League Baseball Players Exemption. My name is Steve Gonzalez. I'm the Senior Vice President and Chief Employment Counsel for Major League Baseball. In addition, there are a few points I'd like to emphasize today. First, to be clear, we're here not because our collective bargaining agreement for minor league players fails to meet state standards, but because both MLB and the players' own union believe that our negotiated compensation structure is most beneficial to the players. Unlike a typical hourly worker, players sought and received part of their compensation in the form of housing, meals, and even signing bonuses. Players also compete vigorously at and away from the ballpark to reach their dream of being called up to the majors. So it doesn't benefit them to have their playing or practice time limited or access to club facilities and resources restricted due to having hourly worker status. Moreover, the party CBA here ensures that players achieve the standard of living intended by Maryland law anyway, as their minimum in-season salary alone would cover them for 56 to 66 hours per week, depending on the player's level in 2024. But it does so while recognizing that the experience of a player is unique compared to hourly workers who can only work at employer-specified times. In other words, this bill recognizes that players should be treated as salaried workers who may perform certain job-related activities for their own benefit and development, even if those activities are not required by the employer. For example, treating players as hourly workers creates a conundrum of determining what hours should even be counted, because players do things on their own time and at home during the season and off season for physical fitness, studying their craft, or otherwise seeking a competitive edge. This is one reason why players are now uniquely paid and receive health coverage year-round, even though the required baseball playing activities are only seasonal. In conclusion, players put in whatever work they deem necessary to achieve their goal of making it to the next level, and this practical bill allows them to preserve. Therefore, urge a favorable report on House Bill 702. Thank you.
Thank you. I want to make sure that our members not only have a chance to ask questions, but understand what the bill actually does, because Keith, when you started, it was so brief, I don't think we even caught what the bill actually was going to do, because the sponsor was not here. Do you mind explaining what the bill actually does?
Absolutely. So this bill creates an exemption from state minimum wage law. So there's already, minor league players are already exempt under the federal law. But this would cover them under the state wage law. So the reason for it is that you want to, it's impractical for minor league players to keep track of their time and actually punch a clock because they do so many activities that are really on their own time. And we wouldn't want to restrict them from coming to the clubhouse to use workout facilities and things of that nature. So this bill, and the other thing I should add for context for my comments is that this is the first time the minor league players unionized for the first time last year. So this is the first ever collective bargaining agreement we've had with this group. And so that's really the catalyst for all this that has changed the dynamic. And the union has also provided a letter in support of making this change because they wanted these other forms of compensation to be, for example, for employer paid housing, because players are transient. They might move up levels or down levels, move to different cities to not have to break a lease. It's just easier rather than get the money and wages to pay their rent, it's easier for the club to, just provide the housing directly. So there are benefits that help them, but given the unique nature of their work. So that's some broad context. So I'm happy to take any other questions you may have about that.
Thank you for the explanation. Do members have questions? Okay, there's no opposition, so thank you very much.
Thank you.
Hope you catch the flight.
Thank you.
Thank you, Madam Chair.
Okay, we're gonna move on to HB 1145 by Delegate Rogers. Workers' comp, occupational disease presumptions, hypertension. Yes, please. Okay, so we have Kenneth Berman, Jeffrey Buttle, John Hall, right? Okay. Matt Pavola, Rashika. Okay. Sud Pabla. Okay. Right. Please go ahead.
All right, Chair Chi and members of the mighty Economic Matters Committee that are still here. I respectfully request a favorable report on House Bill 1145. This bill will repeal the requirement that certain firefighters and other specified related fields experience partial or total disability or death for hypertension to be presumed to be an occupational disease that was suffered in the line of duty and is compensable under workers' compensation law. Currently, hypertension is recognized in statute as an occupational disease presumption under 9-503 of the Labor and Employment Article. This would amend the section to remove the requirement for disablement. Currently, under prevailing case law, disablement is generally considered 3 or more lost days from work. The Workers' Compensation Committee has been denying hypertension claims under 2 scenarios. First, the employee is placed on medication after visiting a physician and is returned to work. Or second, the employer is placed on medication and misses more than 3 days of work as directed by a physician, and the claims are still being denied. Under either of the above scenarios, the Workers' Compensation Commission is essentially nullifying the clear intent of the General Assembly that hypertension is a presumptive occupational condition under 9503. For these reasons, I respectfully request a favorable report on HB 1145.
Afternoon, Madam Chair. Jeff Buttle on behalf of the Professional Firefighters of Maryland here in support of this bill. Just wanted to, this bill was introduced last year as well, and there was a lot of confusion in committee surrounding this bill. And the delegate briefly spoke to it. Some thought that we were seeking a new presumption for hypertension for firefighters. That in fact is not the case. Hypertension is not only currently a presumption, it was one of the original presumptions that this General Assembly passed. And in fact, it's been around so long, it was originally added to the law back in 1971. So for over 50 years, hypertension has been a presumption for firefighters and other first responders here in the state of Maryland. However, there is what the bill is attempting to fix is the issue of what establishes disablement. Particularly, most people are on medication and that fixes the issue. But I think it's important to remember that firefighters that do have hypertension if it's not for them being on medication, not only would they be disabled, they would be disqualified from being a firefighter. So access to these types of benefits are very important to make sure that our firefighters are being treated early to avoid some of the larger medical issues down the road if it's unaddressed. But to keep them qualified so they can still work as a firefighter. And that's really, really important. So we look forward to working with the committee. And with that, I urge favorable consideration of this legislation. Thank you.
Hi, how are you? Distinguished members of the committee, I'm Dr. Rashika Sood. Just a little bit about myself. I'm an internist in Bowie. I've been practicing for about 8 years. And I'm here to discuss hypertension as a disabling condition. If left untreated, hypertension can have fatal consequences, not limited to, but just some of them. It can affect your brain, causing thromboembolic events such as strokes. It can cause hemorrhagic strokes. It can cause myocardial infarction. It can cause acute and chronic systolic heart failure. It can cause kidney problems, chronic kidney problems. People end up on dialysis. It can cause peripheral arterial disease. I can go on and on. But yeah, and they're very fatal. The other things that it can do is that it can be a slow disease, and it can also show up suddenly with minor symptoms, and they come in with headaches, flushing. They don't really know what's going on. We check their blood pressure and it's high. They can get cardiac myopathy, all of these things, which affects their ability to perform.
Good afternoon again. My name is John Hall. I'm an attorney. I represent firefighters and police officers in the state of Maryland. I just think from a practical perspective, the current law in Maryland is that you have to be disabled before you can, we win these cases. Before the commission, per the case law, if our clients don't miss 5 days of work, the opponents of this bill and our opponents in court argue they're not disabled. But in and of itself, hypertension is disabling. In fact, under the NFPA standards, if a firefighter isn't controlled in his hypertension, he cannot perform his duties. Same with the DOT physical. Other issues that come up often with the firefighters, for example, to be consistent, hearing loss is an occupational disease. There's no requirement for disablement for hearing loss. But for a firefighter, you have to miss 3 to 5 days of work. It's a legal fiction. And I've had clients that don't miss work having missed work, we can't file the claim, and then 6 months later, a year, they have a stroke. Well, we can file the claim when he has a stroke, but if we would have had him, the case under control 6 months or a year before, he may not have suffered a stroke. Now he can't work at all. So there's a long-term goal here too for the benefit of the firefighters. And we hear our opponents talk about the cost. I can tell you from a workers' comp perspective, as an attorney, our awards for the workers' compensation cases for hypertension are the lowest. The awards are the lowest, and the medication is what we desire most, and to have our firefighters covered for life for their blood pressure, so it doesn't lead to stroke and heart attacks. Which, if it's not covered, they're not going to be covered with their medications, and they'll be back before us with more debilitating issues. Thank you very much.
Kenneth Berman, also an attorney who represents firefighters. I want to make 3 points. I want to elaborate on what Mr. Hall said about the costs. It's interesting to hear the opposition talk about costs, because actually workers' compensation has a fee guide as to what a physician can charge for an office visit or a medical visit, and that's normally 95% of the time cheaper than what either health insurance or anything else is going to pay. The second part is to the disqualification. What both Mr. Buttle and Mr. Hall were referring to was the NFPA, which is a unique situation that only firefighters have. Municipalities in the state of Maryland are required to follow the federal NFPA. And the federal NFPA says if a firefighter has a hypertension or a blood pressure reading as over a certain amount, as Mr. Buttle said, they are disqualified. So the firefighter is faced with the dilemma. If I don't take the medication, I'm going to be disqualified from being able to do the job, and the county has to get rid of me. If I do take the medication, unlike the rest of the population, I can't file a claim. So last year when we submitted this bill, one of the oppositions was that there was not an objective standard. So we sought to fix that, and we put in, and I think it's parenthesis 2, Roman numeral 1, that the firefighter received 3 blood pressure readings of elevated blood pressure. I've read the opposition and spoken to the opposition, and they don't like that because they think there is no time limit on it or how often the person is going to be evaluated. We're willing to entertain other thoughts, such as a firefighter being on medication for at least 3 months, but it is not a reason not to support this bill.
Thank you. Yes, Delegate Harrison.
Thank you. Mr. Hall, I got a little confused with some of your testimony. So you said that basically, let me just make sure that I understood what you were saying. You were saying that basically what we're trying to do in this bill is to ensure that the firefighters have access to their medication through workman's comp for life. Is that the gist of the bill?
But just the bill is the disabled portion. So what's happening now
Can you
is,
speak into the mic if you can?
what's happening now is when we file the claims, if they haven't missed 3 to 5 days of work, our opponents argue they're not disabled, therefore we lose on that issue. Forget about the presumption, we don't win. So, and I say that's a legal fiction that, the hypertension in and of itself is debilitating. When we win the workers' comp case, they no longer have co-pays on their medication. Once we're in on the hypertension, like I just had an Anne Arundel County police officer who had a heart attack, and that was deemed to be work-related because Wade already won his hypertension. His heart attack, they moved back to the hypertension, said that was one of the reasons why he had his heart attack. So yes, the lifetime medical benefits is key for the firefighters with no co-pays through workers' compensation.
And so what it is that you want the 3-day period to be dismissed.
We're stating that it's disabling in and of itself under the NFPA standards, 140/90. If you're not that or lower, you can't even perform. That's the same as the DOT physical. We're also saying that other occupational diseases like hearing loss, you don't have to have 3 to 5 days. This is the case law in Maryland that they keep relying and throwing back at us. We're stating that based on the fact you have hypertension alone, if you don't take your
Because you've been
medication,
tested 3 times based on the amendment that was just offered, correct?
that's the
Okay.
reasonable standard of medical standard. So a doctor, that's actually a reasonable standard of a doctor. A doctor should take your readings 3 or more times before they medicate you. And I talked to Mr. Berman before we came out here. I don't know any firemen or policemen that want to be medicated for hypertension. In fact, they're very honoring not to do it. So, you know, if they don't have hypertension, they're not going to get medicated. And we're stating that the standard, my belief is the standard, once you're medicated, you're disabled because if you don't take the medicine, you're going to have further problems.
And I think that maybe some of the pushback in previous years was you have to determine ahead of time, and we heard this in a earlier case, is the exam before you go in, and then I'm assuming that firefighters have ongoing exams.
I can answer
because-
that too. Yeah.
So they have to have the exam first, and then they come in with a good baseline, and then over whatever period of time, they get tested 3 times, and then they're deemed to have hypertension. And then they could be medicated.
Correct.
And as long, and if they're not off for 3 days, and they are not considered disabled, and therefore they are disqualified.
Correct.
I'm just trying to make sure that they have a good baseline so that, everyone understands,
Right, and
myself included.
Yeah, the first question that me and Mr. Berman would ask our firefighter that takes a stand, when you were hired by Prince George's County Fire Department, did you undergo a physical examination? Yes, I did. Were you free of hypertension at that time? Yes, we were. Because if they're not, then the presumption, we can't even get the case in to begin with.
And then what is the time frame then that you're looking at? So a 20-year vet, a firefighter, let's just go to 15 years, 15-year firefighter, they're 15 years older, life has gone on.
Right.
And, the blood pressure is elevated. So I guess the biggest question that I think keeps coming up is how is it necessarily determined that an individual hypertension is directly tied to the work, particularly after so many years, and
Right.
just by the nature of human nature of us getting older.
I understand. There's several issues there. One, the more
Please keep
years
it brief.
served as a firefighter,
Please keep it brief.
the more years served as a firefighter, the more toxins they're exposed to. That's the one thing. The other thing is, when we have our hearings, the other side sends them to an expert doctor who on the other side says it's from genetics. Or I'll give you an example that's kind of upsetting to me. When I have my cases, I'll have a doctor say that it's that this person is genetics, or if it's an African-American firefighter, they'll say, because of his African-American heritage, he does not qualify, that it's from his race as opposed to his job. These are the type of things we're dealing with all the time. But the number of years in, you're actually exposed to more toxins and more stress than if you were just on for 5 or 10 years. And we do note, though, that most of our firefighters, it's a younger age. Like if they have a family history of someone in their family has a heart attack or hypertension at age 60 or 70, our firefighters are developing hypertension at age 40, 45, 35 sometimes.
Thank you.
You're welcome. Thank you.
Thank you. We do have another question from Delegate Aaron's.
The day about marijuana in fire departments and how we were trying to work that into the system. But marijuana is a cause, it can actually cause hypertension, it can cause heart disease. Is that something that's considered when you're actually applying for this? We're already doing presumption on it, but is it something that you as a doctor would ask if the use is there?
I do ask, yeah.
Are you allowed to? Are you allowed to ask me if I use marijuana?
I'm allowed to ask my patient.
Okay.
Yeah, and they're not,
But that's a consideration for you.
it's a standard of care that we ask everything affecting.
But I would assume though that if I use marijuana, it would be a consideration for you if I was looking at hypertension. Is that
Yes,
right?
it is a consideration,
Okay.
so that's why we ask.
That's,
it.
it's kind of confusing. Thank you.
Yes,
Thank you.
Any other questions for this panel? Okay, seeing none, thank you very much.
Thank you.
We do have a couple of favorable with amendments, James Lanier and James McAllister.
Madam Chair, members of the committee, my name's Jim McAllister. Years ago, I was driving with my wife in a long car ride, and the song "You Say It Best When You Say Nothing at All" came on, and she looked at me and said, "Right now, that's my favorite song." So it's getting late in the afternoon. We urge favorable review, and I'm going to take that advice. Thank you.
Be clear, we're not, the bill as currently being offered is what we are asking for favorable review. There's no additional amendment.
Thank you, Matt. Matt Pavla, also with the Maryland Association of Justice, and I'll be saying me too, but I did want to point out that McAllister has all afternoon been saying he's practicing over 30 years. I've been practicing over 40 years, so I had that on him. I just wanted to make that point.
Has the added benefit of being true, as Henry Kissinger once said.
Okay, I apologize. I thought I called your name early for the earlier panel, but we ran out of seats. That's why you are here. It's not favorable with amendment. You are favorable, right?
Favorable
Okay.
without an amendment.
Okay, thank
The
you.
amendment that we were thinking of, we have withdrawn. We're happy with the bill as drafted.
All right, great. Thank you very much for
Thank
the
you.
clarification. Oh, make sure there's no questions for you guys. Okay. All right, thanks. Love the brevity. We have some unfavorable here, in person, Lindsay manager, I'm sorry, Julie Murray, Michael Daly. That should be it.
Hi, good afternoon again. Lindsay Beidel-Menninger, Vice President of Legal Services at Chesapeake Employers Insurance and President at IWIF, which is a third-party administrator for the state of Maryland employees. Again, I'm favorable of this bill. And again, saying it's not something that's needed or necessary. Hypertension is often, always, almost always accepted for our firefighters and our police officers, which also have a 9503 presumption, but are not included in this reading in that they would still have to have disablement. Disablement is not 3 days. It is total or partial incapacitation by a doctor. So a doctor could say, oh, you have a new medication. I think you need to readjust to your medication, be out of the office for 2 days or be off of calls for 2 days. And that would be enough for disablement under Workers' Compensation Commission hearings. So then you would have disablement and your normal statute would click in as it does today. So changing the statute to 3 readings, which I'm not aware of when they happen. They'll repeat it. How many days do they have to be apart? Years? What medical reports? Who's doing the readings? There's just so many questions I have already sitting here today that the practical application of it to get to a compensable claim causes concern for me when it's currently accepted. And again, we're just unfavorable because the system is already working for our firefighters and for our police officers, quite frankly. I will leave it to MDC to comment more about it.
Good afternoon again, Julie Murray on behalf of Maryland Defense Council. I just wanted to take an opportunity to explain a little bit more about disablement and how it plays within the occupational disease portion of our act. The current law in Maryland under our act is and has been for a long time that in order to have a compensable occupational disease, you have to have disablement. What this bill does is it takes one specific occupational disease and defines disablement, changes disablement, removes portions of that in a way that's not contemplated for any other occupational disease in our act. And it does so in such a way that, as my colleague mentioned, kind of invites additional litigation with all of the gray areas about when you have to do these blood pressure readings, who they have to be done by, they have to be done at home, in a hospital, by a doctor, how far apart do they have to be done? All of these types of things are trying to fix a problem that frankly is not one that results in denial of claims. Under our Workers' Compensation Act, if a person is found to not have disablement, if they go to a hearing and the commission finds them not to be disabled, all that means is that their claim is not right. It does not mean that their claim is barred. It means that at this point in time, they don't have disablement. They may rebring that claim at a time when they are disabled, which Ms. Menninger just explained a little bit more about what that entails. I'll have Mr. Daly go into a little bit more, but for those reasons, we would ask for an unfavorable report on this bill.
Good afternoon, Madam Chair, members of the committee. Michael Daly for the Maryland Defense Council. I join in my colleagues' basis for the opposition to this bill, and again, ask for an unfavorable report. It's very important to go back over the fact that hypertension is one of the presumptions, that these first responders are in fact getting the benefits they should be getting, that they're medically evaluated, and those that have any modifications of their job. As Ms. Menninger said, there is no 3 to 5 day disablement requirement under the law. Simply, a firefighter could go in and say, my doctor's prevented me from going out on calls, but I can sit at the desk or do whatever else it is that they're assigned to do. That is sufficient under the law to be a disablement. So this is offering in something that is not only unnecessary, it will create more litigation in the commission, because the way that it's worded, both in terms of who's doing the high blood pressure readings, what kind of documentation, what time frame they're doing, and as well as who's prescribing the medication and what's the condition that's being diagnosed. All of those are factors that this bill does nothing more than create more litigation. We believe the presumption as it stands now adequately satisfies all of the concerns and requirements for this first responders. And for those reasons, we're asking for an unfavorable report.
Thank you, Delegate Harrison.
Thank you, it's Ms. Menninger, not Ms. Iwiff.
That's fine too.
Ms. Menninger. So where then do you believe that this 3-day number is coming from? Because we're hearing it over and over, and you're saying that it doesn't exist. But I've been hearing 3 days for a while. So can you tell me where that may be coming from? Do you have any idea?
The AMA guides say repeated tests, but it doesn't say where the 3 days come from. So I'm unaware where the 3-day or three requirement, because it's not 3 day, 3 requirement piece came from, because the AMA guides that it references just says repeat it.
No, the testimony was that if they are, they have to be out for 3 days.
Oh, that's nowhere in the law. It's just total or partial incapacitation. So as Mr. Daly said, if they're no longer allowed to do calls, they're partially incapacitated for purposes of disablement for workers' compensation. So if a doctor says you can't go on calls, but you can sit and take phone calls, you're partially incapacitated from your job, and by case law, you would be disabled under the law.
And and you mentioned that this is both for police, firefighters and police, and
9503 presumptions for hypertension are both for firefighters and police, but this bill is specifically just for the firefighters.
Understood.
Okay.
So how many, because you said that they can already claim this, how many claims have been accepted or denied?
I don't have that data. Unfortunately, my data is a bit skewed in that we often have to figure out who the last injurious exposure is, which means we have lots of volunteer firefighters. So it's who employed somebody last in that capacity to see. So a denied claim could be accepted or denied in the same person, if that makes sense, because we have multiple employers and insurers for Chesapeake. I know that goes deep into comp, and so I apologize.
Yeah,
so I don't have the data.
And I think that the data is very important because, on the one hand, we're hearing these individuals who, quite frankly, run into danger when we run away, saying that they have some very measurable issues. And we're saying, and you're saying that they already have this ability to make this claim, but they don't seem to believe so. And so I think it's important for us to know what kind of data there is, how many, if it's already allowable, how many are actually getting the claims and how many are being denied. I think that's very important for us.
I appreciate that. I think the Workers' Compensation Commission may keep that data because they have all of the data, whereas I just have Chesapeake Employers Insurance and the Injured Workers Insurance Fund data versus the whole state, which, like I said, the commission would
be interested in your data.
Oh, okay. Thank you.
I would be interested in your data. All right. Thank you very much.
Mr. Chairman, and I appreciate my colleague asking that question because data does make a difference. But I want to go one step further here. I heard testimony that everything's fine, but we had a panel of firefighters and representatives saying it's not. So what amendments, if anything, would you come to the table with to fix this problem? Because we have a problem. Does anybody on the panel have any recommendation? Because I think if you heard from the testimony earlier, they were willing to work with people to find a common ground. Obviously, if we can get the data, we can find a solution, but I don't want to hear this is not a problem. If they didn't have a problem, they wouldn't be here. So can somebody tell me an amendment or something that would help solve or get to a point where we can start solving the issues?
Delegate, we certainly would be more than happy to sit down and talk to our friends on the other side. I don't want to say to you today, here's a fix for whatever those concerns would be, but certainly we'd be open to discussions. And I think that's probably the best I can give you right now, but certainly we'd be happy to talk. I will say this, I stand by my testimony regarding my concerns, the wording of the statute now.
That's fair, but I also want to see if you have an amendment or a compromise, right? Because in the legislature, we try and do that and solve the problem. And again, we have parties that have come here that said there's a problem. So I'm just looking for solutions. And every time when folks come to the committee and say, well, we just don't want it. Well, then what else can be done? That's what I'm asking. So thank you.
You're welcome.
Welcome to ECM, Delegate Pruski. We are rubbing off on you. All right. It's not the nickname Thunderdome for a reason. Delegate Rogers.
So I just really want to follow up on my colleague's question. When? I mean, I've heard we'd be happy to have a conversation. This bill was brought last year. When?
Well, we certainly, we were happy to meet with them after today's hearings and sit down and see what we might be able to discuss to potentially work out some compromise to the wording as is now.
I look forward to hearing those considerations.
Certainly.
All right, I walk back in here and all, well, whatever. Okay, that concludes this bill hearing. Next, we will go to House Bill 1285. I think Delegate McComas is here. Come on up, Delegate. Good to see you again. I don't think I've seen you on a bill since the Zoom you were on. Do you remember that?
Oh, yes.
Yeah, I was cool.
Very much so. And I've got my witness that has.
Oh, you got witnesses?
Yes.
All right,
So
bring them on up.
We got a full group here.
And you can go ahead and start whenever you're ready.
Yes, sir. Well, I want to make sure he gets seated.
Okay,
first.
yeah, no worries.
So give you guys a little respite here. This is testimony in support of HB 1285, which is workers' compensation rehabilitation licensed social workers. 1285 is a very simple bill. I know you've heard this many times, but given the amendment that was requested on Monday, which hopefully you have provided to you on February 26, 24, this bill adds a licensed social workers into the section of the labor and employment article that defines rehabilitation practitioner. HB 1285 further clarifies that an LCSWC may also be among the providers, such as doctors and licensed psychologists, permitted to perform evaluations as to the mental or behavioral issues that are being considered in a permanent impairment determination by the Workers' Compensation Commission. Along with my panel today, I have Mr. Arthur Flax, a longtime practitioner of social work in Maryland. His knowledge, training, and experience is the foundation for his unrelenting efforts in bolstering the ethical and responsible practice of social work while expanding the parameters of the practice for every licensed social worker in Maryland. So I would hope that you would give us a favorable report of 1285. Mr. Chair, I just want to know if your file has the amendment, and then we got a reprint and we uploaded it 2 days ago. So I just want to make sure you've got. Oh, okay. I always have to check. I don't trust computers. I like paper. Thank you. And Mr. Flack.
Good afternoon. Let me put this over here.
Okay, you good?
Yeah, I'm right. My name is Arthur Flax. I'm a licensed certified social worker clinical. I'm also a practitioner, G0235, registered with the Workers' Compensation Commission and have been for many years. A licensed certified social worker clinical such as along with the psychologists and certain other ones, we're covered under Title 14 independent agencies, Chapter 08, Guide to Medical and Surgical Fees, et cetera, to be able to be a practitioner with the Workers' Compensation Commission. As such, I'm able to certify sick leave for employees in the state of Maryland, and I'm also able to take people off on TT, temporary total disability. So that's the introduction part. What we're asking here in this bill is, one, as a profession, that social workers, licensed social workers, because otherwise they can become a practitioner under certain circumstances, but only under their degree as a human service type degree for bachelor's and so forth, to be a rehabilitation counselor. But we're asking one thing is that social work, licensed social work as a profession, be included along with practitioner, where it's listed a nurse, a rehabilitation counselor, a vocational evaluator, a physical therapist, an occupational therapist. So it could be, so if people need a case manager, that they be able to do so, they'd be able to use a social worker and know that they can do it. That's one thing. The next thing, it comes back in under 9.721, which Adrian, I can't pronounce your last name, so I'm sorry. Introduced the bill, which passed last year in the House to allow clinical social workers, LCSWC, to testify on permanent impairment. We're asking, based upon another AG's opinion, which I submitted in writing, that on an individual basis, that the LCSWC be able to be voir dired by the court, and that the trier of fact be able to determine whether or not that person can testify on permanent impairment.
Thank you, Mr. Flax. I appreciate it. All right, seeing no questions, that concludes this panel. Good to see you, Delegate. Thank you so much.
Thank you, Mr. Chair.
Yep. All right, we're going to go on to the next panel, which seems to be all the trial lawyers, James Lanier, James McAllister, and Matt Pavola. You can start when ready.
Just for the record, defense attorneys are trial lawyers too.
Oh, okay.
James Lanier on behalf of the Maryland Association for Justice, changed their name many years ago. We are also in support of this bill. I'm going to focus on the vocational rehabilitation side, since the bill basically does two things, one for permanency. So the vocational rehabilitation benefit and work comp, and essentially the third major benefit claim, which is the return to work. It only really comes into play when the worker has permanent injury.
Hey, sir, sorry.
Oh,
Yeah, that's okay.
I stole my microphone.
I know you're an attorney.
Yeah, no one ever tells me
We'll go
to
slow.
Stop talking.
All right, minute 25 left.
Gotcha. So the voc rehab part is where the worker has an injury, of permanent restrictions that are greater than their pre-injury job. So then they're entitled to a return to work benefit, and there's various benefits that go along with that. Part of that is we get a vocational counselor. All parties will agree on who to use for the vocational counselor, and then that person starts working directly with the injured worker. What this bill would do would expand the individuals who could assist the worker to return back to gainful employment by either having a LCSWC work alongside a voc counselor or in lieu of a voc counselor. So it essentially allows for increased input from other licensed and regulated people by the commission to assist the injured worker about returning back to suitable gainful employment. For that reason, for that part of the bill, the MAJ is requesting a favorable finding.
Thank you, Matt Pavola, also with the Maryland Association of Justice, and I'm going to address the tail end of this bill having to do with permanent partial impairment ratings. You'll see that a licensed certified social worker clinical is added to the list of those who can do these types of impairment ratings at the end of the case. What Mr. Lanier was talking about was the beginning of the case. This is now the end. Currently, the statute reads that a licensed psychologist or other qualified physician can determine the nature and extent of permanent impairment involving behavioral mental disorder. This now lets a licensed certified social worker clinical do it because much of what they're doing for the injured worker involves behavioral and mental disorder. It's right down their alley, and they're good at it, and they care, and they're compassionate providers. They are hugely qualified to render these final decisions, these impairment ratings that determine just how bad, how severe the injury is, the behavioral mental disorder is, when it goes before the commission for that final award. So I would just point out in conclusion that there is a dearth, there is a shortage, there is a terrible shortage of such providers right now. Anywhere in the greater Baltimore area, there are only 2, and they're in Baltimore County. Distant counties would benefit by this greatly because licensed social workers could now provide this very valuable, important service. And I'm so glad this is my last time I'm testifying. Delegate Fletcher Harrison asks really tough questions and good questions, and I hope she's not going to ask any here.
Good afternoon, Mr. Chairman, members of the committee. My name is Jim McAllister. It's rare that you get a piece of legislation that really can do no wrong, because in order for the social worker to be used, the claimant's lawyer has to make a decision. I want to have my client rated by the social worker. So if a social worker is somehow inappropriate to do that sort of rating, we have the screening process of the attorney. In voc rehab, both the employer insurer and the claimant's attorney have to agree on a provider. So again, if there's some concern of, people that aren't skilled enough doing this somehow getting into the mix, that's not going to happen, because I'm not going to let it happen. And neither is the employer or the insurance company. Let me go into permanent partial disability a little bit. And whenever I start talking about workers' comp, I'm reminded that a client once said, I have a workers' complication case. And I said, right, you have no idea how prophetic you are. So when you have a permanent injury, something that affects your earning capacity in the future, and workers' comp is not pain and suffering. It's not like a car accident case. You're only compensated for economic losses. The assumption is if you're a 3-legged racehorse going forward and you were a thoroughbred before that, in the future, your earnings are going to be lighter. We call that permanent partial disability, not total disability. So the way you get that is they look at 3 different things. Number 1 is what's wrong with you from a medical perspective. That's the rating. That's what Mr. Pavla has just addressed. And the number of experts that are available to the claimant's bar to do ratings in mental illness cases and mental and psychiatric injury cases has gone down considerably. We had 1 psychiatrist, Dr. Sheehan, in the entire state that would do our ratings. He called me last year and said, Jim, I'm not chewing through the restraints anymore. I'm done doing these. So we have 2 psychologists. So this expands the pool of experts that we can use. And also, I would wager they're cheaper than the other folks. So in minor cases, when the claimant doesn't spend a lot of money on an expert, that means the claimant gets more of the award, more of the compensation. We urge favorable. Thank you.
Thank you. All right, that concludes this panel. Now we'll hear from people who don't think this is a perfect bill. Julie Murray.
Thank you for taking all our bills right in a row today.
Yeah.
Thanks so much.
And we have Nancy Egan virtually, right? Okay, so Julie, you can start, and then we'll go to Nancy, and then we'll take questions.
Thank you. Good afternoon again.
Julie, sorry, 1 second.
Not me.
Michael Daly, if you're here, you can come up as well. Sorry.
You're fine. Good afternoon, Julie Murray again for the last time this afternoon on behalf of the Maryland Defense Council. We wanted to express our request for an unfavorable report on a portion of this bill and express just paint a little picture of what's going on with IME providers and workers' compensation right now. This is undoubtedly a problem that we need some more IME providers to address permanent impairment. And my colleague is going to get into a little bit more about how physicians determine permanent impairment and why it's important that a physician does it. But I'm going to focus on the fact that our commission has actually been very diligent in recognizing this problem and actually currently has a task force set up by our chair, Quinn, who has been working to identify new IME providers in all areas in orthopedics, as well as psychiatry and psychology, to locate and find new IME physicians to perform impairment ratings. It's not something that's being ignored by the Workers' Compensation Commission. They've been very proactive on this, and they've actually had some success so far. So we would ask that that we not make a substantive change to the law by bringing a new type of provider into who can provide impairment ratings, and instead rely on what our commission has been doing in identifying and assembling this task force and looking to solve the problem that way. Thank you.
Madam Chair, member of the committee, Michael Daly from the Maryland Defense Council. Maryland Defense Council opposes this bill in part. Let me start by saying what part the Maryland Defense Council supports. We applaud the ability of social workers to provide vocational services and as detailed in the bill as it stands, certified by the State Board of Social Worker Examiners. I think that's excellent. Bring more providers to provide those types of services to injured workers. We think it's a great outcome. The concern is under our law today, the commission, among other factors, must look to the American Medical Association guidelines to permanent impairment. Without going into great detail of what that book is, it specifically is addressed to be determined and certified by physicians to evaluate patients for a variety of injuries, both physical and psychological. And there's very good reason for that, because those provisions detail things that those physicians and psychologists are trained to evaluate, both in treatment as well as in the independent medical exam evaluations. The reality is social workers simply don't have that type of medical training. That is the primary concern, because to allow social workers to provide evaluations for impairment purposes are inconsistent with the way that our laws stand now. And that would mean you'd have to go back and determine how to determine what evaluations can be even considered. Would the commission even be bound by that, because the AMA guides wouldn't allow a social worker to do that type of evaluation? For those reasons, we're asking for an unfavorable report.
All right, thank you. We have a virtual unfavorable. Ready to bring her up, Nancy Egan.
Good afternoon. Can you hear me?
Yes, please go ahead.
Thank you so much. Hi, good afternoon, distinguished members of the House Economic Committee. My name is Nancy Egan. I represent American Property Casualty Insurance Association, which is a national trade organization. Our members write 89% of the Maryland's workmen's compensation private market. We appreciate the opportunity to provide oral testimony in opposition. I echo what the other two panelists have been saying, and we've been testifying on this bill for several years. We, along with our other members of the panel, have no concern with a licensed social worker to register as a rehabilitation or practitioner in order to provide vocational rehabilitative services. We do echo, though, the concern for a licensed certified social worker to provide evaluation services that are presently only provided for by physicians, psychologists, and psychiatrists. As we mentioned, APCI members are concerned about this departure to non-physician, non-psychologists, non-psychiatrists providing ratings and evaluations, since the evaluations must conform to standards set forth by the American Medical Association's Guide to Evaluations of Permanent Impairment, and therefore have been routinely completed by the above-mentioned physicians. As already stated, this guide provides detailed guidelines for treatment and evaluations. And with that, given the departure from well-settled law and practice, we respectfully oppose House Bill 1285 for providing these type of evaluation services. Thank you.
Any questions for Ms. Egan from the members? Seeing none, thank you very much.
Thank you.
That concludes the bill hearings on House Bill 1285. We now move on to Delegate Rogers, House Bill 819.
Chair Valderrama, members of the Economic Matters Committee, for the record, Delegate Mike Rogers. And I'm here today to introduce and support HB 819, which would add non-civilian employees to the group of federal employees in Maryland eligible to receive financial assistance under the Federal Shutdown Paycheck Protection Act. The General Assembly passed the Paycheck Protection Act in 2019, following the last federal shutdown. That shutdown lasted an unprecedented 34 days and pointed to the need for emergency assistance for employees impacted by the shutdown who might struggle to make ends meet without a paycheck. The Paycheck Protection Act named civilian employees of the federal government as eligible for assistance under the statute, but it excluded non-civilian employees. That is, Maryland's roughly 30,000 active duty service members. These individuals work at installations that include Fort Meade, Fort Detrick, Pax, Patuxent Naval Air Station, Andrews Naval Air Facility, and jobs such as combat training, construction, engineering, healthcare, machine operation and repair, and transportation. HB 819 would extend eligibility for financial assistance during a shutdown to this group of highly important workers, and we encourage your support for this bill. I respectfully request a favorable report on HB 819, and now I'll turn it over to the Department of Labor to speak a little bit more about the program and this bill.
Thank you, Madam Chair, members of the committee. For the record, Andrew Fulgeniti with the Maryland Department of Labor, here in support of House Bill 819, and I'd like to thank Delegate Rogers for his sponsorship of the legislation. As the delegate mentioned, and as you might remember, the department actually came before this committee in early January, and we briefed the members on a potential federal government shutdown and some of the programs that we offer at the Department of Labor to support any impacted workers. This bill seeks to make a small but significant change to one of those programs, the Federal Shutdown Loan Program, essentially by striking the word civilian in the existing statute. So currently the program would only be accessible to civilian federal employees who meet the other eligibility criteria. So this is specific to, again, those you would consider emergency essential employees of the federal government. When the government shuts down, they're required to work but are not being paid. So by striking that word, we're opening up the program and the assistance offered to military service members and impacted during the same shutdown. These are the same service members, like I said, who are required to work but are also not being paid during an extended shutdown. Lastly, I'll just say, Governor Moore has declared this the 2024 Maryland's Year for Military Families, and we feel this bill supports that declaration, again, by kind of expanding the eligibility criteria for those that the bill originally sought to support. And with that, I'd ask for the committee for a favorable report and be happy to answer any questions.
Any questions for this panel? Seeing none, thank you very much. Delegate Rogers, it looks like that concludes the bill hearings on your bill today. There's no other witnesses in oral testimony. We will now move on to House Bill 709, which is Delegate Rogers and Schmidt. That's you.
I have a proxy for this one, Madam Chair. My intern.
Okay.
You pushed it in a little too hard. Good afternoon, Madam Chair and members of the Economic Matters Committee, or should I say mighty committee. For the record, my name is Kiara Wilson. I'm going to be testifying on behalf of Delegate Mike Rogers for House Bill 709. May I bring up the panel? It is an absolute pleasure to be here before this esteemed committee. I am pleased to introduce House Bill 709, which corrects an inconsistency in the code relating to oversight of real estate offices. Right now, Maryland's real estate brokers may only oversee one office location. However, an office manager who reports to that broker can oversee multiple offices. This requirement can prevent a broker looking to expand from one location to a second one due to the cost of needing to hire an office manager. House Bill 709 will align Maryland with its neighboring states on this issue, and I have Lisa May, representing Maryland Realtors, with me today to speak to the bill and answer any of your questions. Thank you for your time, and thank you, Delegate Rogers, for allowing me to have this opportunity, and I respectfully request a favorable report for House Bill 709.
Thank you, Madam Chair, members of the committee, Lisa May with Maryland Realtors, and I won't top that introduction. But as Ms. Wilson described, there is a discrepancy in the code that was brought to our attention from a small real estate broker out of Southern Maryland who was looking to expand his brokerage from one location into a second. And as Ms. Wilson described, a broker can oversee one office location. If they want to expand to a second, they need to hire an office manager. But that is where this discrepancy begins. That office manager can oversee 3, 4, 5, 7, however many offices they can reasonably supervise. But their broker, who is technically their boss, who is higher on the pyramid than they are, can only oversee one. So this can be a deterrent, particularly for those small brokers that are looking to expand their businesses. So we want to fix that. What this bill says is that brokers and office managers have the same ability to oversee multiple office locations, subject to the same requirements that they conduct reasonable and adequate supervision of the licensees within those offices. And we ask for your favorable report.
Thank you very much. Are there any questions for this panel? Seeing none, thank you very much. That concludes testimony and bill hearings on House Bill 709. Is Delegate Vogel here? Does that mean yes? Does he go? He's gonna go. Okay. We will be on House Bill 802, Delegate Vogel, when he walks in the door. Okay, you know what? We're going to move on to Delegate Adams. House Bill 998. Delegate Jackson's not here, Delegate Vogel's not here, so I'm moving on. And as Delegate Fraser Hidalgo said, move unfavorable.
Will you say this conference?
We're on 998.
Okay, Madam Chair, committee members, for the record, Delegate Chris Adams, happy to present House Bill 998 titled Maryland Department of Labor Unemployment Insurance Study on Actively Seeking Work Requirements. My sponsor panel would speak at greater length about this because of the matter, but I'm a retailer, so I can certainly tell you my personal experience, which is why I brought the bill. During the post-pandemic and certainly within the past 12 months, my family business has hired, and we've been searching for workers. And I've seen firsthand the exercise where we reach out to prospective employees to come in and interview. And in one situation, this was for a receptionist job, 5 people were supposed to come in and interview, none showed up. And it begged a question. I mean, I didn't make a big deal about it. I didn't call the prospective employees back. I just simply thought to myself, why would I have 0 out of 5 show up at an employment meeting. So let me just say this for the committee's benefit. We pass a lot of bills related to unemployment insurance. We have some heavy bills this year that relate to what the cost of unemployment insurance is, what we want to do to backstop and support the unemployment insurance trust fund. So I think it's worthy of a discussion, which is what this bill is, a discussion and a study for what is the employee's responsibility on their end to find work as soon as reasonably possible. So if you read the bill, it'll go into what the legislative intent is, but the legislative intent is simple. I'm not making accusations and I'm not making presumptions. I'm simply saying, what are other states doing in this scenario? Can we learn as a state from other states' actions? And for the most part, this bill is asking the Department of Labor to come back to us in the near future and report to us with what they have found. Hopefully what they'll find is nothing, and that my bill was brought for a great reason, but not for the reasons that we thought. But think about it like this, and I'll close. What if we find out that there are certain things that the state could be doing to make sure prospective employees are fulfilling their responsibility for work search requirement? Are they looking for work, actively looking for work? Are they taking work when it's reasonably available? Because it is their responsibility to use unemployment insurance when necessary, but no more than that. And so with that testimony, I present this bill to the committee as a study, and I would ask for your favorable report.
Delegate Adams, it says Kaylee Locklear is on your panel. Is she here?
Well, I think I've covered her testimony. She went to another
gotcha.
bill hearing, so
Okay.
she would have done a better job with what I just did, but I think as a retailer, I'll cover the bases.
Any questions for Delegate Adams? Delegate Rose?
Thank you, Madam Chair, and thank you for the bill. So working as a recruiter for 15 years, I'm wondering, and I missed part of your testimony, so if you covered it, I apologize. So there would have to be some way of also tracking, and I don't know if you address it or if you could put it in as an amendment. So as a recruiter, we are required to post our jobs on all the state websites, and we post them everywhere anyway. There's also a problem with people who apply for jobs just to check the box, but have no qualification whatsoever for the job. So how are we going to address that gap? So I'll have somebody that applies for a programming job, and all of their work history is completely out of the industry, or it has nothing to do with it. So is there a way, or is that something that we can work with the agency to make sure that it actually makes sense when they do check the box? Because I think often they apply and they know they don't qualify, years pass when they actually had to do it.
So to answer your question, because it's a study bill and we're not trying to pass
Yeah.
something that's going to be a mandate on employer or employee, that this could be certainly something we could add to, or just simply, I think we can ask the department to weigh in.
Great.
You can come on up.
And
Absolutely.
I think that would be a great thing to bring up in the discussion. So there should be some sort of qualifying, some check boxes, with computer algorithms and things like that. If somebody doesn't have at least, a couple of the, keywords, I think that would be helpful.
Madam Chair, could my sponsor panel chime in? There you go.
Thank you. Madam Chair, honorable members of the committee, for the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. The issue of ghosting is commonplace. That is a legitimate term, by the way. It's an HR term. I had to laugh about that a little bit too. But we've actually been talking about this issue for years with various departments, and asking the Department of Labor to help us address this issue, as there is currently no way for an employer to go ahead and report in the beacon system when they believe somebody's doing this, or if they no-show for an interview or whatever it is. You have to have the social security number in the system. I can show you all screenshots of that. And then the other issue is Maryland technically has 3 active search for work requirements. So they have one where you have to be applying to a job, and then 2 others that can merely be met by creating a resume on monster.com, right? So we really only have 1. And so we're covering a lot of issues in this study, but I think what the committee needs to think about here is we really need to eliminate as much fraud and abuse in the system as possible, right? We're having these very complex conversations right now, Delegate Charkoudian, about perhaps increasing the benefit or lengthening the benefit. And when you do that, you increase employer taxes. You also impact the solvency of the unemployment insurance fund. So it is incumbent upon us to eliminate as much potential fraud as possible. And that's what this bill does. That's what the study does. We're going to look at what other states are doing as far as active search for work requirements are. How can we verify this? We believe this is a very common sense bill. We hope the committee can support it. I'm glad to answer any other questions. And we actually do have one of our members who I think virtually is going to testify to just talk about that as well.
Thank you.
Thank you. Any questions for Ms. Locklear? Seeing none. Thank you very much.
Okay.
Now move on to the virtual. Stephanie Minsberg. Ms. Minsberg, if you could turn your camera on, please. We require that during hearings. Ms. Minsberg, can you hear us? Unfortunately, I'm not allowed to let you testify unless you're on camera. Okay, we'll move on. We'll now go to the unfavorable, Ms. Christina Moore.
Good afternoon, members of the committee. My name is Christina Moore, and I'm a chief attorney at Maryland Legal Aid, heading the administrative law unit with legal expertise in administrative law and public benefits, and I'm grateful to be here. There are two ideas I'd like to share with you related to this bill. Unemployment insurance is a time-limited resource that provides a below minimum wage benefit to stave off poverty for people who have been determined to meet strict eligibility criteria based on the circumstances of their separation from employment. As a prior recipient of unemployment insurance and a current representative of clients seeking this resource, unemployment insurance is not a benefit that sustains most people's lifestyle. The possibility of eviction and other substantial losses become real, and I'd be remiss not to acknowledge current events and the increasingly frequent threats of furlough for federal employees living in Maryland. What this city seems to presume that unemployment recipients might skip unemployment interviews to prolong the below minimum wage stopgap is preposterous. Please oppose the bill and commit to reducing barriers to unemployment insurance, which at its core is meant to keep people from poverty's door. The second idea is that the mechanism for reporting isn't entirely clear, but this bill seems to entertain expanding Beacon claimant portal access to potential employers, which have no relationship to the claimant, for the purpose of reporting and entering interview information. To be clear, Beacon is a platform the Maryland Department of Labor uses to manage and maintain claimant bank accounts, personal identifying information, as well as the evidence and investigative reports for claims. I strongly oppose any additional reporting that second guesses claimants and specifically to employer access to the claimant portal. However, and importantly, claimant representatives don't have Beacon access, and I'd strongly urge this body to support a study on Beacon access for claimant representatives like the feds already provide for VA and Social Security benefits as a step toward increasing access to the benefit. I thank this committee and urge an unfavorable report.
Thank you very much. Are there any, Delegate Adams?
Thank you very much. Of course, I'm the sponsor, and I with a lot of thought to your testimony, I want to just share that it's a study bill, right? I mean, I'm not making accusations or anything other than that, but my only question on this is, and I hope you and I would agree that we would not want fraud in our unemployment insurance program, no more so than we'd want it in workers' compensation insurance or property casualty insurance, any insurance product, especially one that has, this type of money and how it goes from the employer into the UI trust fund. I mean, there is a fiduciary responsibility that the Department of Labor has. And I would hope your testimony is one of, maybe we don't need the bill, but you would still not want to see fraud, because I'm just trying to go after the fraud component. So your thoughts on my comment?
The Maryland Department of Labor is very active in their investigations of fraud. I've represented multiple clients that have been alleged to have been engaged in fraud. I think that the resources that the state has could be better spent elsewhere. And I think that, again, the goal should be expanding access to the benefit as opposed to second guessing people who have already been determined to qualify.
Okay.
Thank you.
All right. And with respect, if we're going to expand the benefit, I don't think it's unreasonable to ask the same legislature that's going to perhaps pass a bill like that to reinforce the importance of making sure the department is thoughtful about fraud, what it looks like, and then maybe looking at other states and how they're how our state is stacking up against other states. That's all. Thank you very much.
Any other questions? Delegate Howard.
Thank you. So I want to thank the bill sponsor. I'm a retailer, been a retailer approaching 20 years. I'm having the same problem. I put out a job application to about between Facebook and my email list, probably 3,000 to 4,000 people, and got 0. So and I'm seeing this through chamber breakfasts and other retailers that I'm talking to as well. And so I guess my comment really, I'm going to finish it with, isn't that so, is that this is not uncommon that this is going on, and I appreciate the bill. I think it would be very, very well served to look at what we could be doing better. So this is happening in our sectors. And so isn't that so? So I'll just wrap up there and say, isn't that so? So thank you.
If the question is, isn't it so? I would just counter that. I don't think that recipients of unemployment insurance are the target of this.
I don't think anybody's trying to target the recipients of unemployment insurance. I think you're convoluting at best the message. What we're trying to do is figure out why in our business sectors we are getting we're putting out we're hiring to thousands of people on the largest social network platforms and to, quite frankly, customer bases that we all build. So they're targeted. Maybe my kid could work at Chris's carpet laying business, whatever it is, or my retail business. These are targeted employment ads as well, and we're getting 0. And this is something that I'm hearing across market sectors, and that's what his bill is getting to. No one is questioning the integrity or what people that are going after these benefits. No one's questioning that.
I'm glad to hear that.
Yeah, he made it very clear, and now I'm making it very clear again. No one is questioning that. What we're simply trying to do is figure out what we can be doing better as a state to ensure that our retail markets, our construction markets, whatever market sector it is maximizing the benefits of the great workforce, the highly educated workforce that we have here in Maryland. So I don't really understand the opposition, but I appreciate your comments, and thank you, Madam Chair.
Delegate Ahrens.
Thank you very much. To that end, are you saying that this is not happening? Is that what you're alluding to, that we don't need this? That these events where people are signing up because they have to do something and they're not showing up, you don't think that's happening in the state?
I don't have information before me to say that is not a problem that exists in the state, but based on my representation of clients that desperately rely on these benefits, I don't think that it's the fault or target of recipients of unemployment insurance. If there are issues that employers have with recruiting people, I don't think it's because people who receive, again, this below wage benefit temporarily are not applying for jobs or trying desperately to be able to sustain their lifestyle.
I would encourage you look into that because I think we just heard testimony to that. And I believe it's happening because I've seen it happen where people do not show up. They have to check a box. And that is happening. I think you know, to just get better information for yourself. Not everybody, I don't think everybody does that, but certainly it's happening. So I don't know how you deny that, but thank you very much for your testimony.
Delegate Chi.
Thank you, Madam Chair. So I'm trying to understand, is it your concern that this study bill would actually hurt the clients that you have been working with?
I think that it would potentially put up an additional barrier. I think that it, particularly as it involves the reporting aspect of it, could lead potential employers, again, who don't have any personal relationship to the claimant to be, or to have access to very sensitive claimant information. So yes, I do think that in some respects it poses yet an additional barrier for claimants. And I also don't think that recipients of unemployment insurance should be the target of what seems to be a wider scope issue of employers having a difficult time finding employees.
Yeah, I agree. These are two not quite the same issue, but I'm trying to understand how that is going to adversely affect the people who are playing by the rules and just trying to seek the unemployment with the study bill. Yeah, so. Thank you.
Any other questions? Seeing none, that concludes the bill hearings on House Bill 998. We'll now go on to Delegate Vogel.
Thank you, Madam Chair. And is it okay if I bring up our sponsor panel? I guess anyone that's in favor of this bill, come on up. I have a whole list, but it's pretty long. And I apologize that I'm a little late. I also have a bill in the Health and Government Operations Committee right now. Madam Chair, committee members, I am here with House Bill 802, which is a bill to protect workers across our state from captive audience meetings. Captive audience meetings are currently a tool of choice, a preferred tool of choice of union busters. We are seeing them in use across our state in opposing unionization campaigns. And they are also, I believe, a violation of the First Amendment rights of Maryland workers. Maryland workers are being forced to listen to political messaging, anti-union messaging, religious messaging in these meetings in a way that they are coerced to participate in, which once again, as I said, violates their First Amendment rights. I have with me representatives of labor unions from across our state that represent workers that are being directly impacted by these captive audience meetings, workers who have lost their jobs because of these captive audience meetings. And I believe it's time for our state to stand with these workers, stand with their First Amendment rights, and join the list of other states across the country that have put in protections to guard against these captive audience meetings. I will turn it over to, I believe, whoever is ready to go. But with that, I urge a favorable report on House Bill 802.
Good afternoon, Madam Chair and the committee. My name is Brandon King. I'm a member of the Teamsters Local 570 here in Maryland. I want to state my strong support of House Bill 802. I'm here today speaking for the thousands of workers here in Maryland and many thousands across the country who have been forced to sit through mandatory captive audience meetings and who have been intimidated and terminated for their support of a labor union. On November 9th, my job, Ari Michaels, we had a very strong anti-union captive audience meeting. At this point, HR had conducted a meeting to talk about why a union was not in the best interest of them and the company or its employees. At this time, they have allowed an employee who was out on FMLA leave to come into the meeting. HR then allowed him to directly and verbally insult me and my character. My health issues and my past employment were also brought up. At this time, he had continued calling me out, even saying my name, which left multiple of my fellow coworkers in shock. After this meeting, I went to HR explaining how they sat there and created a hostile work environment. Their answer to me was that because he was off the clock, they didn't know if they could do anything. So you mean to tell me someone could just walk up in the company with a gun and there's nothing they'll do because the guy was off the clock? It would be okay, I guess, the way they look at it. So then I proceeded to send the investigation complaint to about the hostile work environment to the HR, and then they directed the same anti-union lawyer who was directing these meetings in charge of the investigation. Ladies and gentlemen, I'm here to ask you to pass House Bill 802. May I continue?
To wrap it up.
How many more Brandons does this have to happen to for our state and federal leaders stand up and back the workers and not the companies? Companies have been able to bully, threaten, and destroy livelihoods, all because employees like myself want to look out for my fellow coworkers and start a union to help with making life that much easier. Due to my fight and me standing up and showing support for wanting to join a union, I'm jobless, not knowing where my next meal is coming from, and not knowing when I'm going to be able to get my insulin again.
Thank you, Mr. King. Next.
Thank you, Madam Chair, members of the committee. My name is Larry Wolf. I'm a business agent with Teamsters Local 570 in Baltimore, Maryland and Cumberland, Maryland. I've been a union member for over 35 years, and I'm also president of the Western Maryland Building Trades. I'm here with my fellow brothers and sisters from the Teamster Councils in Maryland and DC. We represent over 20,000 members in these areas. This bill is near and dear to labor's heart. It's about protecting workers' rights. As you heard from Brother Brandon, he and a vast majority of his co-workers wanted to join Teamsters Local 570. However, on company time, the employer forced them behind locked doors to hear this anti-union rhetoric. And as you heard, and what we're trying to protect is workers' rights to be able to walk out of a meeting like that, to go back to their regular job duties, and not have the fear or the threat of discipline or termination, as Brother Brandon is fighting today to get his job back, and that a vast majority of those workers can have a union contract, because it was for these behind the scenes mandatory meetings that led to the demise of his job. So we're here today in full support of House Bill 802. This is some good pro-worker legislation that several other states have seen fit to pass into state law. And we're here today as a broader group of labor and any other organizations or groups that support this bill. And we ask for a favorable report from this committee.
Before we proceed, sir, we didn't even have you on our witness list, but you've already spoken. So before we go, are you on this list? What is your name?
Kayla Mock.
Okay. Go ahead.
Good to go. Okay. Again, my name is Kayla Mock. I'm here on behalf of United Food and Commercial Workers Union Local 400. I'm also here on behalf of the thousands of at-will employees here in Maryland who have been put through captive audience meetings or will be put through captive audience meetings just for enacting their rights. Because most workers, in the absence of a collective bargaining agreement, are considered at will, employees can be terminated at any time. Employers often try to exercise vast authority over employees' lives, including their political activities or freedom of association. This power is routinely abused to coerce workers into attending political rallies, religious discussions, or anti-union meetings under the threat of disciplinary action. I've been a labor organizer with UFCW for 10 years. There's tons of stories I could tell you about captive audience, but I want to leave you with one. When I was first an organizer with UFCW, we were charged with working with a group of drivers who were organizing their union. They started organizing because a coworker had died in an accident on the highway, and their boss showed very little empathy about this. When these workers were primarily African-American and Latino workers, I think there was maybe 1 or 2 women among them. And so when they started organizing, their boss decided to hold captive audience meetings. These workers were split into 2 groups, Latino workers and African-American workers, where the boss proceeded to tell the Latino workers, you don't need a union, it's for the lazy workers in the other meeting. In the Latino workers or in the African-American workers group, he said to those workers, it's not for you, it's for the people on the other meeting who don't know English and don't know their rights. These workers were not allowed to leave these meetings. This is what this bill is trying to do, to give workers the right to say, no, we're not going to sit here and listen to rhetoric, especially in that instance, racist rhetoric about our coworkers. And so we appreciate it. We hope that this bill is found favorable to stop this kind of meeting and allow workers to leave freely.
Thank you very much. Are there any questions for the delegate and his panel? Delegate Pippi.
Thank you, Madam Chair. Delegate, good to see you in the committee.
Good to see you, sir.
So question, I'm reading through the testimony and I'm assuming that if a bill prohibits a meeting talking about, let's say, anti-union, would it also prohibit meetings talking about pro-union stuff?
So to be clear, and I want to note one thing that I missed earlier, there are some amendments to the bill, so I want to make sure to flag that for you. This bill is seeking to regulate conduct, right? So it's not prohibiting an employer from having a meeting. What it's prohibiting is an employer retaliating on an employee who chooses not to attend that meeting. So theoretically, if there was an employer that was holding a pro-union meeting, I don't see why. I mean, there could be circumstances where workers wouldn't want to be part of that meeting, but I don't think that's really what employers are using captive audience meetings for right now.
So if the Frederick County Public Schools had a meeting encouraging their members to become school board union members and a Frederick County teacher refused to participate, would this prohibit her from being retaliated against?
Yes.
Yeah. Okay. If, and I'm looking at the definition of, well, I tell you that I like. I'm looking at the definition of political speech here, and I'm just wondering, is there a scenario in which if a company chose to have, let's say, diversity training and people refuse to participate in that, could this bill, could there be some implications with that?
I'd have to get back to you on that, delegate. I mean, the language I think is pretty clear, especially with the amendments. And again, we are not regulating what companies are able to hold meetings on. What this bill is focused on is preventing retaliation of employers on employees.
No, I get it. Yeah. So, I mean, obviously it goes without being said, but let's say a company maybe wanted to introduce some diversity training and then you had employees that said, oh, no, I refuse to participate in that political garbage. And so I don't want to participate. I'm going home and you can't retaliate against me because it's political. This training is political in nature. I mean, what are your thoughts on that?
I think that's outside the scope of the bill. I think we're talking about 2 different things when we talk about, and again, I would direct you to the amendments that and clarify exactly what kind of language we're talking about, right? When we're talking about policy or legislation, right? We're not talking about or trying to make workers feel a certain way about policy or legislation. That's not diversity training, right? So I think those are different things, but if you want to clarify further, we can have that conversation, delegate.
Thank you.
Any other questions for this panel? Seeing none, thank you very much.
Thank you.
Now call on Matthew Girardi and Brian Weibel.
I don't believe Matthew Girardi is here today, so I'm going to go ahead and get started. My name is Brian Weibel with the Maryland State and DC AFL-CIO, and the reason we are signed up as favorable with amendment is actually because we were able to work with Delegate Vogel to take the bill and conform it to some of the other captive audience ban legislation that has been seen in other states that the AFL-CIO has tracked. and directly kind of to some of the questions that some of the opponents have occasionally brought up. This is fundamentally a bill about the workers' freedom to not be retaliated for not attending one of these type of meetings. To the delegates' questions about the contents of what type of meetings would be considered, this is not just about union captive audience meetings. This is about, as he brought up, political matters. Political matters is defined in the bill pretty narrowly to include a couple of different things specific to legislation. I will mention this in no way, shape, or form infringes upon an employer's ability to communicate casually with their employees, nor does it infringe upon the ability of an employer to communicate with employees about things required by the law. So that is already addressed by some of the amendments. I will also say there have been people that have raised concerns about NLRA preemption. That is absolutely not the case. The state has the authority to set minimum standards. And it is also worth noting that the National Labor Relations Board is currently considering an across-the-board nationwide ban on captive audience meetings right now that is under consideration. So for the sake of employee rights, for the sake of employee freedom, religious freedom, political freedom, and the ability for those employees to decide for themselves those things and not face retaliation for not attending their employers' mandatory meetings on this, I urge a favorable report with the amendments that have been sent over to you. And I will flag, I emailed my testimony to all the members of the committee due to the fact that we didn't get those in time.
Thank you, Mr. Weibel. Any questions for Mr. Weibel from the members? Seeing none. Thank you very much. We now move to the opposition. Kaylee Locklear with Maryland Retailers Alliance.
Good afternoon, Madam Chair and honorable members of the committee. For the record, Kaylee Locklear here on behalf of the Maryland Retailers Alliance. We are unfavorable on this bill, and I am going to hone in on the union portion here. Our members do believe that federal law does preempt the creation of these laws. And because of the preemption issue, as well as free speech issues, a lawsuit was filed jointly in the U.S. District Court for the District of Connecticut. Plaintiffs are our counterparts at the National Retail Federation, along with many other groups that have participated in this suit. And I just wanted to give some background here. So most labor law issues in the United States are governed by the National Labor Relations Act. And then that is enforced by a federal agency. That agency is the National Labor Relations Board. And there are a couple of arguments about why we believe that a finding of federal preemption would be warranted and why we'd like to warn the legislature about passing something like this. So this law prohibits mandatory employer meetings that are protected by federal law. I'm glad to go into that. The bill intrudes on issues that the United States Congress intended to leave unregulated by the states. And then finally, the legislation's restrictions on speech raise serious First Amendment concerns that may warrant invalidating such laws as an unconstitutional infringement on freedom of speech and religion. So trying to ban quote unquote captive audience meetings is not only chilling employer free speech, but eliminating workers' ability to seek answers to questions that they may have about unions or the fact that they may not want to join unions. So I'll stop there. I'm glad to answer any questions you all have with regard to those comments.
Delegate Boifo.
Thank you so much, Madam Chair. Hi, friend. Good to see you in the committee. We do this dance every couple of weeks here. So help me understand this. You talked about a Connecticut law. How many states actually have captive audience laws?
You are correct. So Connecticut, and I think there's 3 others that have passed laws.
And so for the 2 others outside of Connecticut, how many have gone to a lawsuit?
It's just the one lawsuit that's pending right now. Correct.
Connecticut. Okay.
We're waiting for that.
The other 2 laws are on the book. They're fine. There's no issues in those states.
There are issues, but we're waiting for that lawsuit.
There are issues not from a legal standpoint, but from the realtor standpoint, right?
For the retailers, yes.
The retailers. Sorry,
yes.
I always get that confused.
It's okay.
All right. So you talked about the federal laws that preempt this. Can you kind of point me to that in particular?
Absolutely. So here we go. So if you look into the National Labor Relations Act, NLRA, because I'm going to use this acronym to make it easy. So first of all, employees have rights there. They have a right to form, join, or assist labor organizations. And they also have the right to refrain from any or all of such activities. And that's just a brief summary. I'm glad to give you more on that. And then you go into the employer protections that are afforded here. So if you look under the NLRA in Section 8C, it says that the expressing of any views, argument, or opinion, or the dissemination thereof, whether it's written, printed, graphic, visual form, shall not constitute or be evidence of an unfair labor practice under any provisions of that act. So we believe that it's very clear in federal law that they're actually protected in holding meetings that share different information about joining unions.
So I actually you talked about Section 8C and the NLRA.
Yes.
Let's try to get that right on my side.
Yeah.
But it doesn't talk about what happens if an employee decides to try to unionize and what the repercussions are for an employer who tries to take retaliation. Right, which is why I assume that out of the 3 laws, I think all 3 have gone through a lawsuit at some point in time. 2 have been dismissed, and the one in Connecticut, I assume, will end up in the same position. Have you guys gotten any opinion from the Attorney General, who also was a former member of Congress and a co-sponsor of the national captivated bill that the House Democrats tried to do 2 cycles ago?
We have not. There's an extraordinary amount of case law that is cited here. I'm glad to share that. That is what we are operating off of and has been cited in these suits.
Well, I'll encourage you guys to work with the bill sponsor on trying to get an AG's opinion, because I do believe that there is some parts of federal law that are missing that the states can kind of step up here to protect both employers and employees at the same time.
Great. Thank you.
Delegate Harrison.
Thank you. I just actually wanted to hone in on the retaliation part of this bill. So an employer has a right to have whatever meeting he wants to have, and I don't think that anyone has a problem with that. The problem, I think, becomes the possible retaliation. Can you just speak to that and if you have opposition to that, or just to clarify your position, your organization's position, particularly on that part of the bill, please?
We did not have a comprehensive conversation here about retaliation, so I'm glad to get back to you on that. We were more so focused on the arguments where we believe that the law is preempted, and then there are First Amendment violations potentially in here, but I can follow up with you. I think we have a meeting here in an hour.
Yeah. So, but I think that part is extremely important because, besides just the captive meeting, the problem then becomes retaliation. And if an individual ends up losing their position because they choose not to listen. So regardless of what the meeting is, everyone, I would think, in these cases anyway, should not be required to stay at a meeting that they're not really interested in if it falls under these categories. I think Delegate Pippy mentioned, a couple of instances, but the retaliation is the problem.
An employer or an employee theoretically should not be compelled one way or another here.
Right.
And the NLRA is supposed to strike that balance, but I can follow up with you on that.
Yeah, I think that's very important, and particularly having a conversation with the sponsor of the bill as well.
Great. I'll do that.
Thank you.
Any additional questions for Ms. Locklear? Seeing none, thank you very much. That concludes the hearings on House Bill 802. And now move on to Delegate Jackson with House Bill 871.
Good afternoon, Madam Chair,
fellow members of the Economic Matters Committee. For the record, I am Delegate Carl Jackson here today in support of HB 871, Business Regulation, Catalytic Converters Record Keeping Requirements. Catalytic converter thefts have increased significantly in recent years because of the precious metals that they contain. The Baltimore County Police, for instance, has recorded nearly 1,700 catalytic converter thefts in the last 3 years in Baltimore County alone. These statistics highlight a continual issue of catalytic converter theft that must be resolved. Driving without a catalytic converter can damage components of the exhaust system, and replacing one once stolen can cost between $800 and $1,200, adding further monetary damage to the victim. Once dismantled from a car, catalytic converters can be sold to licensed automotive dismantlers for about $100 per converter, though the precious metals in them can sell for much more, or to a scrap metal processor. Scrap metal processors are currently required to record the purchase with information about the car and the seller. However, automotive dismantlers have no such requirement and are not required to record vehicle or personal information when they purchase the converter. Therefore, there is no record of which vehicle the converters were obtained from or who sold them if purchased by the automotive dismantler. This loophole allows catalytic converter thieves to easily sell to automotive dismantlers without fear of a paper trail that the police could use to crack down on these thefts. The automotive dismantler then sells the catalytic converters to a scrap metal processor who extracts the precious metals. HB 871 would close the loophole by requiring that automobile dismantlers must record the purchase of the catalytic converter with the VIN of the vehicle that the converter was removed from, as well as personal identification about the seller. Through requiring this identification information in the first exchange between the person selling the converter and the automobile dismantlers, HB 871 will help discourage illegal selling of catalytic converters. For these reasons, I urge a favorable report of HB 871. Thank you.
Madam Chair, members of the Economic Matters Committee, I am Baltimore County Police Chief Robert McCullough, here to express Baltimore County's support of House Bill 871. A persistent problem that we continue to encounter in Baltimore County is the theft of catalytic converters. Once a thief steals the converter from a vehicle, this victim must now pay between $800 to $1,200 to repair that car. This is an out-of-pocket expense unless their insurance policy provides comprehensive coverage. In order to profit from this crime, the thief must sell the catalytic converter to an individual or business that can extract the precious metals from the part. The current loophole that exists in our state law is the ease of the thief to sell the converter to an automotive dismantler. The thief can sell without providing any identification nor any information concerning the vehicle which was the source of the catalytic converter. The precious metals contained in a catalytic converter, palladium, rhodium, and platinum, all have significant resale value in the metals industry. The dynamic situation creates a crime that involves little risk and large reward. This bill is a step towards identifying the thieves who are responsible for victimizing our citizens. This reporting will help law enforcement determine the source of sold catalytic converters. House Bill 871 is not a prohibition of the sale of purchase of catalytic converters. It merely requires reporting into the statewide electronic database. Dismantlers are already reporting the purchase of vehicles into this system, as are junk and scrap metal dealers reporting their purchases. With this in mind, Baltimore County Police Department requests a favorable report for House Bill 871. And I've also brought along my experts, Detective Phil Crombacker and Detective Harry Singh, who investigate these crimes.
Thank you. Sean Benson, also with Baltimore County Police Department. I would defer my testimony in support of this bill and be willing to answer any questions.
Any questions for Delegate Jackson and his panel? Delegate Aaron's.
Thank you. Just a quick question. How do you track this? So there's no serial number on a catalytic converter, is there?
No.
So you're gonna hopefully track it when I sell it. If I steal this thing, I'm gonna go sell it. You're gonna know I sold one, but you don't know where it came
But
from.
I think the hope is that they actually have them report the VIN number of the vehicle in which the catalytic converter comes from.
But if I can't attach the catalytic converter somehow to that vehicle, I don't know where it came from. So
Right.
somebody's getting it, but your hope is just to stop people from taking them because we'll get somebody logging it in that they got this, and then somewhere the victim isn't made whole on this in any way, right?
No, I mean, the bottom line is to close the final loophole around this problem. And it's not only our citizens, but, you know, businesses, car dealers also are victimized by this.
I like I said, I like the idea. I just don't know how, I'm trying to figure out how better to do it if it was easy enough to actually serialize those things. That way you could tie one to a vehicle if that was something to manufacture, because it is a big deal. I know it's happening all over. But anyway, I appreciate your answers. Thank you.
Any other, Delegate Rose?
Oh, thank you, Madam Chair, and thank you for the bill. And I've had one of them stolen myself. So I was just interested from law enforcement. So it seemed like that was happening a lot, and then it sort of died down for a while. Are you finding a lot of victimization of people using the park and rides? That's where it happened to me. And you can explain how quickly they can get in there with those sawzalls and just lop those things off. Can you just speak to that? And Delegate Aaron's asked my other question, so.
We pretty much see these things happen almost anywhere. I mean, the thieves, all they need, like you said, is a sawzall. And they typically just ride around and they look for secluded places or late at night when no one's around. And they pull up to, you know, to a few cars, parking lot, shopping mall, big box store, and they lop off the, you know, those catalytic converters and they're gone within minutes.
So I guess to follow up from Delegate Aaron's question, so how would this equate to, because you can go to pawn shops sometimes and track down stolen goods and things of that nature. You think just enough deterrent knowing that they have to like at least come up with a VIN number and give their information? Would they have to give ID as well to who they're selling it to?
Yes, they would.
Okay.
That would kind of close that loop, and because you know, as I've been told that basically this loop allows them to get around those mechanisms, and you know, there's a lot of money involved. They steal it, they get money for it. Then those people that are buying it sell it to another person in the chain that then sell it to someone else they typically send it overseas. They take all the precious metal out of it and they create new catalytic converters and then sell us new catalytic converters back for the people that are having their catalytic converters stolen.
Okay. And to the detective, are you the detective?
No, actually, it's
Oh.
Phil Fromberg.
Yes.
So my question would be, so they're going to be required to give the information, and typically do these places, if you're working a case, you know, if you have a chronic amount of it happening in one particular area, would you be allowed in your processes of detective work to go and get, you know, video from those places so that you could see who they said they were? You would be able to see if it's the same person coming in over and over again, so that if there is a store that is, or a dismantler that is kind of in on it, do you think this would be very helpful to kind of break up some of these rackets?
Yes, ma'am. So how the chief explained it, how it works, usually in the state of Maryland, all you need is a scrap metal license, costs about $10. If you have a scrap metal license, that individual could buy a catalytic converter from anyone without asking him or her where those catalytic converters are coming from. That scrap metal license, whoever owns it, would then sell it back to the recycler, and the same thing is happening. They don't have to ask questions of where they're getting the catalytic converter from, and they're not serialized. I could see video in the recycler who's selling it, but no one knows where it's coming from. And majority of the time, and throughout my investigation, I've caught several individuals doing it. After interviewing them, they saying, yes, we get a list by whoever has a license. They tell us to go and steal these catalytic converters from certain vehicles. We come back, give it to the scrap metal, whoever has a license. They sell it and they take a profit, whatever percentage they get.
Do the ones that are doing this, do they get sentenced? Do they get, or is there?
If we
Okay.
catch them in act, yes.
Okay.
But like I said, majority of the time, we don't see them because they're selling it to whoever has the license.
Okay.
And throughout the whole process, the process is no one asks questions or well, how did you get 20 converters? Why are you giving 20 converters to go sell to a recycler? And they're not serialized. I just had a case not too long ago in Baltimore County. A company lost over $250,000 in catalytic converter with theft and the loss of replacing them.
Thank you very much.
Delegate Turner.
Madam Chair, not to be sounding like I'm crazy, but for a person that don't know what you're talking about, what it look like again? Can you just describe, is it this small? Is it, what is it?
So the
'Cause
catalytic converter.
I don't know nothing about cars.
Ma'am, if
Okay.
the muffler, are you familiar with
Yeah.
the muffler? It's right next to the muffler. It's about a box with this size.
Oh.
So what it does is the emission, it takes all the toxic out of it, so it does not pollute, it lessens the pollution of the toxic going out into the air.
And so it's easy to
Yes.
remove it?
Yeah, so how I've actually followed several individuals doing it and
Uh-huh.
caught them in an act. So what they do, they carry a portable jack.
A jack.
Yeah, a portable jack, and they go around looking for these cars. It depends on the make and model, depends on where they get it from, the make and model, the price goes up in catalytic converter. So if you go under a car, it takes about, I time it 1 minute and 20 seconds, between 1 minute 20 to 1 minute 30 seconds. They jack it up, go under, use a sawzall, cut the converters out.
Now, I just wanted to ask a question to the sponsor. The sponsor, do you think when the car dealer place, when you're buying a brand new car, and do you think they should put the numbers on that converter when the person get a brand new car to stop all these steps? They can find them easily if the number is actually bought on the car with that number on it, right? How did you say it, they get the number off the car? How did they?
Well, they
find
have to
it?
report the VIN number for
Oh.
which they got.
Report
Cadillac.
VIN number.
Mhm.
Okay, I got, okay,
Yeah,
I'm
but
following.
they don't print the VIN numbers, from my understanding. on the
No,
catalytic
there's,
converter.
there's no way of, if you sell a converter to a recycler or a
Yeah.
scrap metal license, there's no way telling where these converters are coming from. There's no serialized
No
number.
way,
So
huh?
if you sell it to someone who's receiving it from a scrap metal license,
Uh-huh.
with the bill, it would help us, law enforcement, figure out where this catalytic converter is coming from. So we could trace it back if it's stolen.
That is stolen. Okay, thank you. Okay, I just had to follow you because I didn't even know what it looked like.
It's pretty, depends on the vehicle, depends on the size.
Okay, thank you.
Thank you
Matt.
very much. Any additional questions for this panel? Seeing none. Thank you, Delegate Jackson. We'll now move on to the opposition. Danielle Varanian and Gary Jones.
Thank you, Madam Chair and members of the Economic Matters Committee. My name's Gary Jones. I'm an attorney from Baltimore and Annapolis with Baxter Baker, and I had the privilege of working with some of the same individuals back in 2009, 2010, and 2011 to pass one of the leading metal theft reporting statutes in the country that we worked on for 3 years. So a lot of these areas were covered at the time. I represent several scrap processors, including Sims Metal, which is the largest scrap metal processor in Maryland. And we agree with the problem. Indeed, we've had individual thieves that have come into our yards, jacked the car up, cut the catalytic converter out, and the jack fell, the car crashed down and killed the individual. We've had that happen twice. And we our certain clients, have tried to be a part of the solution here. Thank you for Delegate Jackson in inviting us a couple of days ago to have a discussion by Zoom with the Baltimore County Police Department and the stakeholders and Sean Vincent. I worked with Sean Vincent on the original legislation back in 2011. We have some proposed amendments that are being circulated today. I just got brought into this literally about 48 hours ago. And we've requested a follow-up meeting, or are requesting a follow-up meeting with Delegate Jackson with the stakeholders. And our intent is to try to come up with a bill that solves the problem. We'd like to have the loophole closed, but there's some tweaks in the language, particularly on page 4, that we're going to be proposing, and we'd like to have a meeting on and work toward a solution. So that's where we are.
Thank you. Any questions for the panelists? Seeing none, thank you very much.
Thank you. And my partner, Danielle Varanian, is in another hearing, so she will not, I'm it.
Thank you. I was just about to call him. Thank you again. That concludes the hearing on House Bill 871. Moving on to our final bill of the day. Delegate Johnson, I know, is not here, but his chief of staff is here to present House Bill 859.
Members of the esteemed Economic Matters Committee, thank you for allotting this time to introduce House Bill 859 on Delegate Andre Johnson's behalf. This bill addresses licensing renewals for real estate brokers and the continuing education of real estate licenses to the Maryland Real Estate Commission. The primary purpose of this bill is to eliminate certain processes related to the expiration of licenses for real estate brokers, associate brokers, and real estate salespeople. This legislation will establish a staggered basis for licenses to expire with the intention of refining and establishing specific timeframes for license expiration. Additionally, this bill will authorize the State Real Estate Commission to set fees under certain circumstances, alter regulatory requirements for conducting continuing education courses, and mandate entities to submit continuing education course information to the commission under designated circumstances. Overall, this bill would allow the commission to efficiently manage the high volume of expiring licenses and the influx of continuing education courses being submitted at the same time each year. My panel can describe the bill in more detail, and they'll be happy to answer any additional questions you may have.
Thank you, Madam Chair and members of the committee. I know it's been a long day, so we'll try to zip through this one. And we thank Delegate Johnson for bringing the bill forward. So as was described, real estate licensees
I'm sorry,
are
you're
required.
Lisa May?
Yes, I am Lisa May with Maryland Realtors. Thank you. Real estate licensees are required to take 15 hours of continuing education credits to renew their licenses over 2 years. And it might surprise you to know that some of those licensees wait until the very last minute to complete those credits. They're allowed to do that currently, but it does create some issues on several fronts when they choose to do that. Once a licensee completes their CE class, the education provider needs to report that information to the Real Estate Commission. That is a timely process of line-by-line manual data entry that can't be completed when a licensee is completing their classes at 11:59 p.m. The day before their license expires. The Real Estate Commission attempted to address this by reducing the time that CE providers have to report the credits to the commission, going from 14 days down to 3. But the continuing education providers, of which Maryland Realtors and our local associations have said that that has created a hardship for them. And they are considering reducing their course offerings or raising prices to address this additional and condensed reporting requirement. So what we want to do with this bill is try to address all of those issues. We want to create an incentive for licensees to complete their continuing education 30 days before their license renews. We want to restore the 14-day period for continuing education providers and allow for a more orderly process of CE reporting to the Real Estate Commission. And we ask for your favorable vote.
Thank you. Delegate Ahrens.
Hi, Lisa. How are you?
Very well, Delegate.
It's good to see you. Hey, I just thought, I appreciate you talking to me about the bill beforehand, but some of this bill, it looks like we have 2 years to renew. And with computers, as I started thinking about this, with computers and all that stuff, I know when I take my CE classes, I get done with that class and I register for it. They have my name, they have everything they want. All they have to do is either enter my name in there. Typically, they have that electronic and hit a button and the computer should be able to do that. I think they should be able to do that immediately. And I understand you're trying to cut the times to give them leeway, but I would rather, instead of seeing me have now to have, instead of 24 months, I'll have 23 months to do this. In my world, I fixed this because I actually take my classes beforehand, but my license expires in March and I'm in here in March and I'm working. But I see if you do go over, I get punished as the person because the system's not giving me 24 months. I'd rather see you tell them or tell the system, the system itself, to give the agent the extra 15 days. If I end April 1st or March 31st, let the system fix that as opposed to the agent paying a fee and having a problem with it. It's a suggestion. I mean, people should be able to learn to work through this, but it's coming back as the agent, and the agent's doing everything they can. Good agents try to keep up on it. And if they aren't going to get their license, they're going to be suspended anyway. But that puts the impetus back on the people to report it faster as opposed to me to have to jump through hoops, because sometimes it's almost impossible. Wouldn't you agree?
Thank you, Delegate. Yes, we have tried to find a way to work within the real estate commission system, which is incredibly antiquated. We even said, it's 2024. Isn't there some way that we can upload an Excel spreadsheet that has all of this information, like import it? And they said, no, their system does not allow them to do that. They are apparently, as I know, in line for an IT system upgrade, which might make this solution right now obsolete in a few years. But until that time, we are trying to represent, the best interests of both our Realtor members and the continuing education providers.
Couldn't you make it 25 months renewal then? Again, I'm being serious because it is a problem. People do wait till the last minute to do this. That's why you have the bill. But we're going to punish me as the agent who's out there working, generating the revenue, blah, blah, blah. And I just see it might have been easier just to tell them, you know what, instead of 24 months, we're going to give you 25 months and then pay the piper. Because I'm not deliberately doing this. I'm caught. But thank you.
Thank you.
Are there any other questions for the panel? Seeing none, thank you very much. That concludes the bill hearing on House Bill 859, and members, that concludes the bill hearings for today. And as asked, to remind the members that you are expected and appreciated to be at the venue this evening.